Today we will be working through the materials on the multi-state bar exam on contracts. As we work through these materials, I am going to reorder pages a little bit, but I'll let you know where we are as we're going along, and we're going to take the same approach that we took yesterday, reading questions aloud, discussing both strategies and the substantive law that's implicated in those areas. Contracts, certainly as much or more than torts or some of the other areas that we have seen, is one where there are a great many rules that can potentially be examined, but the nature and the substance of the questions that tend to actually be asked fall within a restricted range of those. That is, they don't tend to examine on absolutely everything under the sun that might come under the contracts umbrella, but rather in specific areas that are especially examinable because people tend to be confused by them or find the rules difficult, and so that's what we will be focusing on. So the introduction, again, mentions, just as with torts, that approximately 33 or 34 questions will be in the contracts area, but there isn't such an easy breakdown as we saw with torts, where we saw that approximately half of those questions were on negligence, and so you want to focus your attention there. With contracts, there's no single topic that gets quite as much attention as that. A lot of different topics that we're going to work our way through, recapitulating the typical structure of the contracts course, that is beginning with offer, etc., working our way through to remedies for breach of contract. So the first point that's made in our materials, which is one that you want to keep in mind, is that if the Uniform Commercial Code applies, you will not necessarily be told that. That's something that you'll be expected to know. And so really the contracts area is a combination of common law contracts that dates from a pre-UCC world, plus the UCC to the extent that it's been pretty universally adopted. So we're not going to work through lots and lots of fine details of the UCC, but you need to be aware that to the extent that it is now the predominant rule, it's the rule that you will be expected to know. So as you read through fact patterns, you do want to be asking whether the UCC applies. So the next page to which I want you to turn your attention is actually your page 125. Then we'll look at the question that is on your page 124. I think those are side by side in your materials, so it's not difficult to swap them. The first topic we'll be talking about in contracts is the first thing that arises chronologically, right? If we think about the life cycle of a contract or a contract dispute, and that is offer and acceptance. It's important to be able to distinguish, understand the difference between the unilateral and the bilateral contract. The unilateral contract being one where the offer can be accepted by performance, and the bilateral contract being one where the offer can be accepted by a promise of performance. And in fact, of course, in our modern world, even though we don't exactly think about it that way, the overwhelming majority of contracts are bilateral, and in fact, what is being exchanged typically are only promises. Right? That is, promises to perform and promises to deliver the goods, etc., are the typical complex commercial contract. That is not the contract that arises when you go to a grocery store and buy an apple, right? But if you buy that apple with your debit card, if you buy that apple with your credit card, in fact, what you are giving is a promise of future payment, not payment, right? The consideration that you are giving takes the form of your promise to pay, right? With consequences for failure to pay, etc. So the bilateral contract is certainly the more common contract, but that's not to say that you will not be examined on the unilateral contract, which has the strange character, right, that it can be accepted without the offeror necessarily exactly knowing that has happened until the performance on the other side is complete. And so that raises lots of kinds of questions that are then easy to examine about. So the first of those we'll see in our question number 1, which has to do with offer, how an offer is to be accepted, the effect of accepting an offer, and so forth. So we'll start out in our familiar way. This is a long question. As you can see, if it were arranged slightly differently, it would exceed a column, and so we follow our same rule that absolutely with any question where the fact pattern exceeds a column, you definitely want to go to the question first. So we'll start over here. Sir, with you. So number 1.
In a lawsuit by Slicker against Duffer for breach of contract, what would the court probably decide regarding Slicker's letter of October 9?
All right, so that's what we're going to be paying attention to. right? Probably today, the question would have more of the legal content that's relevant up there in the question, right? That is, it might say something about revocation or offer or acceptance, because the question as it is phrased here, you can't generate an answer. That is, what would the court say about it, right, is very close to which of the following is most correct. That is, they could say lots of things about it, and we don't even know yet from reading that what this question is about. Right? So we'll think about ways the question might be reshaped, would be likely to appear in a slightly different form today, even if the answers were the same and the subject matter being tested were the same. But certainly on the basis of that, we've got to read the facts. We can't even begin to speculate. So now the facts from the top.
Duffer and Slicker, who lived in different suburbs 20 miles apart, were golfing acquaintances at the interurban country club. Both were traveling salesmen, Duffer for a pharmaceutical house, Slicker for a widget manufacturer.
Right, and again, with a fact pattern that starts like this, you have no idea what this question is about, right? And there's a lot of detail in here that isn't relevant to answering the question. I think there are fewer questions today that are written with that kind of irrelevant detail. You're like, 20 miles apart, what's going to be the significance of that? They're friends from the golf club, what's going to be the significance of that? Well, as we're going to see, it's of no significance whatsoever. It's not what the question is about, but you don't necessarily know that as you're finding your way through it. Go ahead.
Duffer wrote Slicker by United States Mail on Friday, October 8th. I need a motorcycle for transportation to the country club and will buy your two jockey for $1,200 upon your bringing it to my home address above stated in letterhead on or before noon, November 12th next. This offer is not subject to counterclaim. Sincerely, Duffer.
All right, so it's being made very explicit here that this is an offer. Right? That is, if we didn't have that last sentence, you would have to understand that this is an offer. This is making it even more clear that it is an offer. What kind of contract is being proposed here? That is, as between unilateral and bilateral? Because? Right, writing back to say, okay, I agree, doesn't count as accepting the offer, right? That is, it can only be accepted by performance, namely by bringing the motorcycle to such and such a location. Okay? Go on.
Slicker replied by mail the following day, I accept. Promise to deliver the bike as specified.
Right, so that's the letter of October 9th, right? Not quite as clearly. I mean, the first time I read this through, when it says the letter of October, it's like, what letter of October 9th? But we've got the offer letter of October 8th, and then we have this reply letter of October 9th. What, if anything, is the legal significance of that letter?
That it was not an acceptance. In fact, it was a rejection of the offer.
Well, how is it a rejection of the offer?
Because he did not reply by the manner specified in the offer.
What, right, so it's at least not an acceptance. Maybe it's a counter proposal, right? Maybe. Go ahead.
Well, what about the last fact in the offer that said this offer is not subject?
What is the significance of that, if any?
Well, that is an express term, I guess, of the offer, which demands acceptance in a very specific manner. And it specifies that any manner other than that will not be viewed as an acceptance of this offer, and it will...
But let's be clear about what is meant by this offer is not subject to countermand. Because this offer is not subject to countermand purports to bind the offeror. Right? That's like the offeror saying, this offer cannot be revoked. Right? But that itself is like a mini promise inside the larger contract. And it's a separate question whether, if an offeror says, I won't revoke this offer, whether they can still revoke the offer. Right? Because that's the significance of this statement. This offer is not subject to countermand. Is the offeror saying, in effect, this offer is irrevocable? The question is, does an offeror saying this offer is irrevocable bind the offeror not to revoke? Now that's there's a rule of law here. right? So does an offeror saying this offer is irrevocable prevent the offeror from later revoking it if it has not yet been accepted? Correct, right? So once it's been accepted, then the offeror can't revoke it. They're bound, there's a contract, right? That's properly accepted, right?
So it's redundant.
It's not anything exactly, right? Because it doesn't mean what it seems to mean, right? And
So
that,
it's not redundant?
no, he's trying to add a term that he can't really add, but that's better for him, right? That is his power to revoke. I mean, we'll see this again, for example, in the wills area, right? You can promise not to revoke a will and still revoke the will. That's just not the kind of thing, right? Because, and to put it in purely contract terms, the promise not to revoke this offer is not supported by consideration. And so he's not bound. Now that's different than whether someone says, give me $10, right, and I won't revoke the offer for 30 days while you figure out if you can perform. Then we've got like a mini contract. That is, we've got a contract not to revoke the offer. That's it, like a little mini contract inside the bigger contract.
So then that statement is disingenuous.
Correct.
So then
Correct. It's a gratuitous promise and
So is that
doesn't mean a
evidence
thing.
of bad faith?
It depends what our question's going to go on to be about, right? But it doesn't have the significance it seems to have. That's the point. It can't be taken at face value. So what we have is an offer of a unilateral contract which can only be accepted by performance, an offeror purporting to render that offer irrevocable, and then a kind of purported acceptance, like an acceptance in quotes because it's not in the right form. That is an attempt to accept, taking the form of a reciprocal promise when what is sought is not a promise but performance. On this basis alone, we can start looking through our answers, but that's only because we are ahead of ourselves, right? But we certainly can assess the legal significance knowing that the question is about what would the court probably decide regarding the letter of October 9th. So now we actually have as many facts as we need because nothing that happens later actually will be relevant to answering the question. There are other questions that could come out of it. But let's jump ahead to look at our question now and see if we know enough to answer our question.
Well, we can say that C is wrong.
Why?
Letter bound both parties to a bilateral contract, but only when received by government. We know that the letter does nothing, does not bind either party.
Okay, so C is wrong, and we saw answers like this yesterday. C is wrong for two reasons, right? Because, I mean, what C suggests is that an offeree can convert an offer of a unilateral contract into a bilateral contract by accepting with a promise instead of performance. And that's just not the case. It's not remotely the case.
Well, he also ignored the specification in the offer. The offer specified the manner of acceptance.
Correct. And so that's all right. So we eliminate C. What about A?
The letter bound both parties to a unilateral contract as soon as the mail, then that's a wrong.
Because?
Because again, this letter has no binding effect under.
Correct. It's a promise to perform, not a performance, and so it doesn't create a unilateral contract. Okay, so now we're down to B and D, right? How about D?
D. Regardless of whether Duffer's offer had proposed a unilateral or a bilateral contract, the letter was an effective acceptance upon receipt, if not upon dispatch. That's a wrong answer also.
Right, because a letter that contains a promise to perform, it's not regardless of whether it was unilateral or bilateral, right? So we've eliminated D. And now B? B is the answer that's left.
Mailing the letter of itself by Slicker did not, mailing the letter by Slicker did not of itself prevent a subsequent effective revocation by Duffer of its offer.
Right. So we've gotten there by process of elimination. What makes the question potentially hard, I mean, there are a couple of things that make it potentially hard, some of which would be less likely to occur in the way that questions are framed now, which is that we didn't exactly know what the question was about, right? But we're able to answer it with half the facts, right? And we have confusing, complicated facts coming, and it's not, we're better served in not reading them at all if we don't have to. It's that what might make people reluctant to land on B is not fully understanding the effect, or rather the lack of effect, of this offer is not subject to countermand, right? Because we don't know, we haven't read far enough in the facts to see that he's going to then try to revoke the offer, et cetera, right? But process of elimination will still get us there, right? That is, even if you don't even if you don't quite remember or don't know what the word countermand means or don't quite remember what that rule is, it's pretty easy to eliminate these other answers.
Well, yeah, I mean, B is really the only answer that's just not
That's even possibly right.
obviously wrong.
Correct. It's the only one that's even possibly right. And so that's kind of a reminder that one of the types of questions you will sometimes encounter, even if it's not quite what the bar examiners intended, is a kind of least wrong answer, right? What you're being asked to do is select the best answer. There may be no perfect answer, no answer where you can't say, yeah, but if it weren't, it might be like this, and then that one would be wrong too. That may be so. But if you've got three answers that are misstatements of the rule of law, they can't be right. There's no world in which they can be right. And one where you don't think it's really a great statement, but it's at least in the ballpark, that's your best answer. Don't get hung up on it. Right? Don't get hung up on the fact that it is not a perfect answer. Now, we might as well read through these facts so that you can think about how to generate a more difficult question out of these facts, because that would be a good exercise for getting more material out of our question. That is, writing another question and then generating answers to it. So read on. We won't spend too much time on it, but read on.
Sincerely Slicker, the letter, although properly addressed, was misdirected by not received by Duffer until November 10th. Duffer had bought.
I mean, that's partly testing is dispatch versus receipt, when there's a big gap of time and events that happen in between, right?
Yes. Duffer had, it's already, obviously.
For us, yes.
Duffer had bought another Suzuki bike from Cool Cat for $10.50 for a few hours before. Cool Cat saw Slicker at the Interurban Country Club on November 11 and said, I sold my Suzuki to Duffer yesterday for $10.50. Would you consider selling me yours for $9.50? Slicker replied, I'll let you know in a few days. November 12th, Slicker took the Suzuki to Duffer's residence. He arrived at 11:15 a.m. Duffer was asleep. I answered Slicker's doorbell ring till 12:15. Duffer then rejected Slicker's bike on the ground that he had already bought Cool Cat.
Right. So there's a much more complicated question, much more difficult question to be asked here about, has he validly accepted, and if so, when, and is the offeror bound, and can you, right, all that stuff, but you're not being asked any of that stuff. So you want to write yourself a harder contracts question. There are a couple of them lurking in here. Who's liable for anything, anybody, etc., right? But not the question you're asked, right? And so it's one of those things where if you've read and this might be one where you'd want to take a glance at the answers, right? That's when you look at the question first, you'd want to glance through the answers so that you could see, oh, okay, what this is about is acceptance and how you can accept, and not read on, because it just gets more and more confusing. I can hardly keep track of what even happened here.
Well, I was going to say, from a strategy standpoint, at least taking this test, this is a quagmire. I mean, this is literally like a big
Right. And it's like you're trying to figure, who's Cool Cat, and how did he get into this story? Right, and you're looking at all these numbers and dates and times.
It has nothing to do with the
Correct. Correct. So don't be, sometimes you really do have to drag yourself through every detail of the question, right? And again, as we see this when we do property questions, and there's some complicated map and easements or some recording act, you can't ignore any of it, but sometimes you can. So when you can, do. If there's enough there to answer the question, and again, it requires a certain degree of self-discipline, right? That's like once you realize this is an offer and acceptance question, nothing that happens after that letter is relevant. So don't read it. Don't waste your time, right? Unless you got time to burn, and even then, it's only likely to make things more difficult. And when you try to look at the question, you're having to sort of forget about all this stuff that happened on November 10th, 11th, and 12th, and cast your mind back to October 9th. Why not just answer once you've got enough facts to answer?
Well, it's just wasted your energy.
Right.
You can't do that for a question.
Right.
You can't waste energy.
Right. And now here's question 2, the harder question, right, out of the same facts. Okay.
What is the probable effect of Cool Cat's conversation with Slicker and the report that Cool Cat has sold Suzuki to Duffer on November 10th?
Right. This is the harder question, right, that forces you into those facts. Now, again, keep in mind, these days you don't typically have two questions coming out of one fact pattern. And so it would be one of these questions or the other, right? That second question is the harder question because it requires you to read all of it, right? Even though it's really about the effect of that conversation, the effect of that conversation is affected by by whether they had a contract or not, right? Because it's different. If there was already a contract between them, the effect of the conversation is very different than if there wasn't. And so question 2 forces you through all of this analysis, and question 1 does not. Okay? So now we've talked it through, and now we really do have to look at what happened in what order, right? So we have this letter, but we've already figured out that the letter does not create a contract between them, and as a result does not prevent the offeror from withdrawing the offer. All right? So we know that, and that takes us through to this, it wasn't received until November 10th, which is kind of the red herring that's about dispatch versus receipt, right? But it's irrelevant, right? Because if the letter, no matter when it was received, doesn't constitute an acceptance, it doesn't matter when it was received. As of November 10th, or November, I guess, Duffer had bought the bike from Cool Cat a few hours before, right? So as of November 10th, there's no contract, right? So now Duffer has bought somebody else's motorcycle, right? But of course, one is allowed to buy more than one motorcycle in the world, right? It's not like buying motorcycle A means you can't somehow buy motorcycle B, right? You can buy as many motorcycles as you want. So buying the motorcycle can't bear, right, on the offer, right? That is, we've got this offer to buy motorcycle A. Someone goes out and buys motorcycle B. Now, that may mean he doesn't want to buy motorcycle A anymore, but it doesn't mean that the ability of the owner of motorcycle A to form a contract by performance has somehow gone away. Not merely buying motorcycle B, an event that isn't even known to the offeree, right? So the question is about the conversation with Slicker and the report that he sold his Suzuki to Duffer, right, on November 10th. So Cool Cat is the owner of motorcycle B, right? So someone has offered to buy motorcycle A, right, and then buys motorcycle B, and the owner/seller of motorcycle B then reports to the owner of motorcycle A, I just sold my motorcycle to the guy who has offered to buy your motorcycle. Okay? Put that way, what is the legal effect of that conversation, if any? Do you think? Well, let's look through our answers and see if we can figure it out. Okay?
It wasn't an irrevocable offer,
Correct.
so A is wrong.
Right, that's the problem with that. Right, that's the problem with answer A. Right, the no legal effect.
Well, as long as it's not November 12th, we can still drive over there.
So it seems. So it seems, right? Because that's about understanding that saying the offer is not subject to countermand doesn't make the offer not subject to countermand. A is a false statement of the law. Yes. What about B?
The conversation doesn't terminate Slicker's power of acceptance
Okay, why not?
because he can still accept it.
Right, or so it seems. So let's move on. What about C?
This report has no legal effect because the offer had been made by a prospective buyer Duffer rather than a prospective seller.
Right, that's a false statement of the law. That is, whatever the rules are about offer and acceptance, it doesn't matter whether it's a buyer or a seller, right? That's just a false statement of the law, not even possibly true. Right, correct. Whatever the rules are, they don't turn on that fact. What about D?
Cool Cat's conversation with Slicker on November 11th terminated Duffer's original offer and operated as an offer by Cool Cat to buy Slicker's Suzuki for $950.
Okay, so as between B and D, which do we think is the superior answer? What's the general opinion? I think B is the superior answer, but I think it's not a great answer. That is, I think that this is a which is the best all in all, not which is the perfect one. right? Because I think one can buy more than one motorcycle in the world, right? And we don't actually have enough facts, right, to really understand, right? That is, if as the offeree, it is clear that events have transpired that would make your acceptance, even by performance, duplicative or something like that, then it's right to say that finding out that someone else has accepted by performance or has otherwise fulfilled what the person was looking for will terminate your power of acceptance. I just don't think this is actually a great example of that situation, right? I mean, imagine something that is much more obviously one-time-ish, right? And I don't know what that would, to paint the house, right? Well, it's true, you could have your house painted twice in 2 weeks, but you're not going to, right? So if someone says, I need you to paint my house, right, except by showing up on such and such a day, and 2 days before someone tells you, you know what, I painted his house just last Saturday. Well, you've lost your power to accept by painting his house, because someone's not going to have their house painted twice in 2 weeks. I just don't think this is a great factual example of that. So it is correct as a matter of the law that if the subject matter of the contract has been fulfilled, right, your power of acceptance has been terminated. I just don't think these are great factual circumstances for it, right? So it's not, I mean, what's wrong with answer D, right, is that it doesn't terminate the offer. It cuts off the power of acceptance. It's just that I don't think these are great facts for bringing out the difference between termination of offer, termination of power to accept, and termination of offer, right? Because somebody else's statement can't really terminate the offer. What it cuts off is the power to accept. But again, I think what's a little problematic about this one is this person could be a motorcycle collector, right? Jay Leno is a motorcycle and car collector, and buying one has absolutely nothing to do with buying another one, right? And how much are we supposed to get out of, you know, I need a motorcycle for transportation to the country club, right? That, are we supposed to extract from that fact that exactly one motorcycle is how many he needs? Right, not a great example, right? But don't get caught up in that. You're not going to encounter this exact question, right? So the rule that you want to extract from it is that when the offeree of a unilateral contract learns that the subject matter of the contract has been fulfilled or performed, their power to accept is terminated. Again, even if these are not ideal facts for bringing out that particular fact, think of one that is more, you know, that is more suitable for that.
When the offeree of a unilateral contract learns that the subject matter of the contract
Performed
his power of acceptance
is terminated. So again, a better example is something that's more unique, so that it really, I mean, again, what we're thinking of is, you know, versus the motorcycle collector. But we're not supposed to be thinking of this person as a motorcycle collector. We're supposed to be thinking of them as needing exactly one motorcycle. And so once you find out that the potential buyer of your motorcycle has his exactly one motorcycle, it's over and you've lost your chance. That's the idea, right? But again, for your own purposes in reviewing this law, it would be worth even taking out that part of the facts and asking and understanding whether he has performed, because that's all, there's also that in there, right? Has he performed? He arrives at 11:15, asleep, doesn't answer the doorbell until 12:15, right? But he's performed, right? What he was required to do was show up at noon, and so then the question would be, that would arise from those facts would be, if he tries to demand payment, right, will he win? And yes, he will, right? Because when he showed up before noon, that is setting aside that his power of acceptance has been terminated. Take motorcycle B out of the story, right? And just let him show up at 11:15 or whatever it is, 11:15, and then have the other guy not answer until 12:15. Is there a contract? Yes, there is. Right, so if we're following that, the only reason there's no contract in this story is because his power of acceptance has been terminated by learning that the subject matter of the contract has been performed. All right, page 127 asks us which of these offers have been effectively revoked, which is another way of saying in which of the following cases has a contract been formed. All right. So you want to read that offer, and we'll go around just even though I'm sorry, yeah. The first offer on page 127.
I offer to buy your 1992 Zip Mobile GPO for $8,000. You accept and tell you I no longer want it.
Contract or no contract? Don't worry about what form the acceptance takes. Assume if it says that the person accepts, that they accept in the right form. That's right. No revocation of an offer after acceptance. Right? That's just the basic rule. Right? No revocation of an offer after acceptance, assuming the acceptance is proper. If it's not proper, it's not an acceptance in that sense. Okay? The next one? So what kind of contract is proposed there? Right, it's not a promise to find the dog that gets you $1,000. It's finding the dog that gets you $1,000. Okay, go on. Contract or no contract? Because? Right, this proposes a unilateral contract, which is accepted by performance. It's accepted, it's performed, can't be revoked. Okay, next one. You can go, we'll go in circle. Okay.
I am a car salesman, give you a signed offer to sell you different deal for $35. The offer states that it's good for 1 month, and then call you up later and tell you that I changed my mind.
Right, so this is an example of a UCC question that doesn't say it's a UCC question, right? So what's the answer? Is there an irrevocable offer here? Because? Right, this is the merchant's firm offer rule. Right, so ordinary people are allowed to revoke their offers in ways that merchants are not. So this is the merchant's firm offer rule. And so that also, going back to our earlier example, or the facts of our questions 1 and 2, maybe some of those additional facts are given to make clear that this is not a merchant in motorcycles whose offers can be irrevocable, but rather just a person buying a motorcycle. Our next subject is the mailbox rule, the dreaded mailbox rule. And as the preparers of our materials state, questions testing the mailbox rule are a favorite of the bar examiner, examiners. That's because this is an area where there are definite rules, and that's right? That is, this is an area that has right and wrong answers, right? And so you want to be careful and answer in a systematic way and make sure that you get it. And we will work through some examples of that. I have chalk, and so I'll be able to take you through the different possible formats that I think are helpful for this. So we will work through the sheet on page 129 and then do a couple questions in this area. So the question, when is it effective if properly sent by mail? Right, this is this dispatch versus receipt question. The offer is effective when? When received, right? Because how in the world would the person even know, right? So that's sensible. The revocation of an offer, also upon receipt. So this is part of what's going to set up these crossing in the mail, right? The acceptance is crossing with the revocation of the offer, and what happens? When is the acceptance effective? Upon dispatch, as long as it was properly sent. But if it's not properly sent, then it's not effective until it is received. So that is assuming it goes to the right address and so on, and so you are given that information typically in the questions because it makes a difference, right?
So this is the mailbox bill.
Yes.
You just place it in the mailbox and properly addressed. Properly.
You place your acceptance in the mailbox, yes. When is the rejection effective? When received. And when is the counteroffer effective? Also when received, because a counteroffer is just an offer, right? It's just another name for an offer. It's a different kind of an offer coming from the other side, right? So the tricky part of the mailbox rule is that the acceptance is effective upon dispatch. It's the exception, right? Notice that it is the exception. Everything else is not effective until it's received. The acceptance is effective upon dispatch, right? And so if the acceptance is dispatched properly before the revocation of the offer is received, a contract results. Right? So if there's an offer outstanding and the offer is accepted by a letter properly put in the mail, on the same day that the offeror puts a revocation of the offer in the mail, there is a contract, because the acceptance is effective upon dispatch, but the revocation not until receipt, right? Which is going to be later. So we can schematize this in the following way. This is the order of events. The acceptance, then the revocation, and, well, let's see if I do this way. If the acceptance of the offer happens before the revocation, right, a contract results. All right? Just as if there were no revocation, a contract would result. All right? If the revocation is received, so we have an offer, and then a revocation received, right, before acceptance, there's no contract. If the acceptance and the revocation, right, are dispatched, right, on the same day, there's a contract. So it's just a matter of setting out the order of events, right? Keeping in mind that the properly addressed acceptance, right, is effective upon dispatch and nothing else is effective until received. So you may have to create a timeline if you're given a bunch of dates so that you can see what's actually going on. And you also want to keep in mind general rules, including that an offer cannot be withdrawn after it has been accepted. Right? That is, once there is an offer and an acceptance, there is a contract. And now the rules about the revocation of the offer are gone. They're no longer available. There's no offer now. There's a contract. And so the offer cannot be revoked. Mm-hmm. Not until receipt. That's right. Right? And of course, you can imagine how complicated this is in an electronic world, because it's like seconds count, right? Also, keep in mind that, of course, these are bilateral contracts we're talking about, right? Because we can generate a sort of crazy unilateral contract where the performance is the putting of something in the mail. But in the ordinary case, what's being put in the mail is a promise to perform. Right? So this is a bilateral contract situation, typically. Right, so again, if you look at the facts that we saw in our first problem, part of what they were doing in that problem is confusing you, right, into thinking there were mailbox rule issues here, when there really aren't, because it's unilateral contract and the letter's irrelevant. Okay? No, it's okay. No, after noon on the 12th, the offer just expires. Just expires. So that performance after the offer has expired is arguably a counteroffer, right? That is, if you show up on the 13th with the motorcycle and say, I want $950, that's an offer,
It's just
actually.
It basically.
We reset to zero. Right. So what you might think what you're doing is accepting an offer, but in fact what you're doing is making an offer, right? Because the prior offer has expired.
Well, isn't that the operative effect of an acceptance in a manner that is other than the one specified in the offer?
Yeah, I think arguably it's a counteroffer.
And that's always
Yeah.
the way I
Mhm.
is that when an offer specifies a very specific form of acceptance.
And you do something else.
That's right, then it effectively creates a new offer and the initial offer dies because you have essentially rejected that specific offer by accepting it in a manner that is other than that initial.
See, but I think that's not quite true, right? Because I think it's not that it is a counteroffer, but I'm not sure it's a rejection of I'm not sure that it forecloses you from especially in this unilateral bilateral. See, I think there's a difference between whether a promise to perform when what has been sought is performance has the same legal effect as an offer to perform in a different way than the promise sought in a bilateral contract. In other words, the typical bilateral contract, right, 100 widgets for $100. If you say, how about 100 widgets for $200? That is clearly a rejection of 100 widgets for $100. But I think in the unilateral bilateral, it's not so obvious that you are foreclosed, right, from accepting by performance by offering to perform in a bilateral fashion. We'll see. I don't know if we're going to encounter it. I mean, it's a subtle question, and it may be more of a subtlety than you'll be required to know. All right, question 3. So it's shortish, right? Shortish. It's half a column, so you can start where you want. And we're on page 130. Okay.
Which of the following best describes the legal relationship between owner and
Right. So that's not the way the question would now be asked, because that is which of the following is most correct, right? Which is not the style. If we look into the answers, and of course we know where we are, the question today would read, is there a contract between owner and plumber as of April 5th? And then it will be yes because, no because, no because. Right, so that's the question. Is there a contract between owner and plumber as of April 5th? So we're going to have to pay attention to dates because they're going to be in there, right? And that's the question. Is there a contract between them as of April 5th? So now, begin.
After several days of negotiation, the owner wrote to plumber that he needed $3,000 if he will install new plumbing in my office building. Thank you. I must have your reply by March 30th. Plumber replied with my letter that he will not do it unless he is $3,000.
All right, what is the status of things between them right now? And rejection of the offer, right? As we were just talking about, right? That is saying no to your offer, here's my offer, right? That is not in any sense leaving open the ability to accept the initial offer. This offer has been rejected and a counteroffer proposed. Okay, go on.
On March 20th, plumber wrote to owner, I changed my mind. I will do the work until you stop and set your permission responsibility. I will cancel it.
Does that work?
It does.
Who's this coming from? No, it's the same guy who rejected. Yes, you got to keep track. You got to keep track, right? And the rule here is no acceptance after rejection because the offer is dead. Right? So this is really just another counteroffer. Right? We've got counteroffer number 1, and then we've got counteroffer number 2 at a lower price. Right? But you can't bind someone with your own performance. Right? That is, you can't say, I mean, this is like saying, you can't write to someone and say, I'll paint your house for $1,000 and I'm going to show up and start painting and somehow bind them. It doesn't work like that, right? That is the performance, in a unilateral contract, the performance sought must be the performance of the offeree, not the performance of the offeror, right? Go on. Okay, so is there a contract between them? And which answer best states that? Yep. That's the only one. Now again, I think in terms of answer structure, today it would be likelier that you'd have yes because, no because, no because, as opposed to this, which is yes, 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 no. Right? In this, once you know there's no contract, you don't have to do any further analysis. So now I think it would be, we would want to separate the correct way of analyzing why there's no contract and the incorrect way, right? So maybe one of those answers would be about the offer was terminated when, and the other would be the counteroffer was not accepted or cannot be accepted by performance or something like that. That would actually force those apart because there are different ways of coming. I mean, here, right, it's a yes or no question, but only one of the answers is no.
Would it be correct to say that once you read, will not do it for less than 3,500, in your mind, if you click on, okay, that offer's dead.
That's right.
And then you look down for any new communication
Right.
by owner, and you don't see it, then you can immediately go down and
There's no contract.
into the see if
Right.
indeed knows no contract.
Well, right, but this is one where we have to read all the facts to find out whether there's any response.
Right.
Okay? But I think not a hard, I mean, this question is too easy in a way, right? Again, because it's yes, 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 no, which I think you'd be less likely to see now, right? And also a yes answer, there would also probably be a yes answer that would say something about how owner's silence implies acceptance, right? Which it doesn't here, but under some circumstances it might. And so then you would, in order to lead the student to think, well, is this one, and after all, he offered him $3,000 and he later said he would do it for $3,000 and now he's showing up and doing it, right? So maybe an answer, another way that an answer could make things more difficult or confusing would be to say, yes, they have a contract at the $3,000 price, right? And then you might think, well, he offered it, he accepted it, now he's painting, isn't that enough, right? It wouldn't be enough, that is, none of this changes the answer, right? But it would make the question a little more difficult. Okay. So on page 131, we have a little worksheet here on offer and acceptance, which we will run through. That is, they're not set up in the multiple choice format. But again, if you are looking for contracts questions and want to spend some time generating questions, these would be very good ones, right, to generate, with your answer structures being yes because, no because, no because in each case, so that you understand both the outcome and the reason for it in each case, right?
All the questions on the MBA, MBE, yes because,
Only if they're yes, no. They might not all be yes, no, right? Not all questions are yes or no, but the ones that are will be yes because, no because, no because. Most of the time. Every once in a while there will be, the evidence is inadmissible. It's admissible as this, admissible as this, admissible as this. So that would be the 3-in-1 yes, no, but those questions are in a way easier, right? And so less common. Yep. All right, so now we'll run through these hopefully relatively quickly. And another way of thinking about the question, which of the following offers has been validly accepted, is in which of the following cases has a contract been formed? Okay. All right, so we'll start with, we'll just hopefully can go through them pretty quickly.
In a poster I put up in the supermarket, I offered a reward of $1,000 if whoever finds my little brown follower.
Okay, this is a deja vu experience. Okay, same.
Next day, you read my poster and set off to find follow. A few days later, you get lucky, you succeed in getting my beloved blue sky.
Okay, contract?
Yes.
Yeah, it's all there. It's a unilateral contract. The offer is accepted by performance. The person performs. Okay, next one.
Mike offers to sell you his car for $8,000. A week later, he sells it to your brother who drives to your house and says, "Look at the great car I just bought for Mike." You immediately call Mike and accept it.
Because? Well, the question, that isn't, it's close to the reason, but it's not quite the reason. Imagine, what's the right way to put it? Yes, that's a better way to put it. Right? By selling the car, he revoked the offer, and the offer is irrevocable. It's not a merchant's firm offer situation, something like that, right? Because maybe he was breaching by selling the car. I mean, if the offer was actually irrevocable, then he would be breaching by selling the car, right? There would be a contract and it would have been breached. That's not the same as no contract, right? So another way of putting it is, has there been a breach of contract? Answer, no, because there never was a contract.
So he's free to make the offer to the person.
Correct, and here acceptance comes too late, right? And it's not irrevocable, right? Acceptance comes too late. Okay, all right, the next one. Okay, so this is the same, right? That is, it's an, but now it's the other side, right? It's an offer, the offer's been rejected, there's a counter offer. Is there a contract? No? Mm-hmm. Right, no contract yet. Yeah. Okay, next one.
On May 1st, your offer to sell you both $5,000. May 2nd, mail a letter to get an acceptance. Will be called you instead of the vote offer. Your idea is on May 6th.
Contract or no contract?
Contract.
Because? Correct. So again, if we think about how the answers would be structured, right, the answers might be, there's a contract on May 2nd, the offer was irrevocable. So the right answer would be the contract was formed upon dispatch, not that the offer was irrevocable, right, or something like that. So we can see different ways that you could get it right or wrong, right? But this contract is accepted upon dispatch, sent properly if you're not told otherwise. Okay. Next one. They're not numbered. Yeah, these are not numbered. This is a worksheet that's on page 131. Okay, go on.
On October 1st, Sarah offers to sell you her lawnmower and says that she must receive your acceptance by October 5th. On October 3rd, mail a letter to Sarah that says, I accept your offer. The letter arrives.
It is not. This is not exactly an exception, but an additional kind of nuanced rule that you want to be aware of, which is sometimes called the offeror is the master of the offer, right? So the actual terms of the offer will override these background rules, right? So if the offer provides that it is not validly accepted until receipt, that controls. It's only if it doesn't say anything about it that the ordinary mailbox rule controls.
So, yeah, so the specific request within the offer
Controls.
will override or vitiate the mailbox rule.
Correct. Yeah, the mailbox rule is a default rule or a background rule. This is a private area of law, and so parties are free to deviate from it if they want, and so provide. So that's terms of the offer override, and you can see that's an easy yes because, no because, no because, right? Because it's easy to get it right or wrong, right, depending on whether you're aware of that rule. All right, so the wrong answer, right, would be that it's not a contract. Let me think about how to put this. It's not a contract because the letter doesn't arrive in time, which is the right answer, right? The terms of the offer control. And the wrong answer would be it's not a contract because a contract is never accepted until receipt, which is false, a false statement of the mailbox rule. Right? So this is not an example of the mailbox rule. This is an exception to the mailbox rule, right? That the terms of the offer control. Right? And then we know the wrong answers are easy, right? Yes, there's a contract because it was dispatched in time, etc. Or yes, because the offer is irrevocable. Okay. All right, next one.
My offer to sell you my television. I then die. You come to my home and say to my spouse or executor, I accept that offer to buy the television. Oh, and by the way,
Contract or no contract?
I
We have another little rule here, and the question is, do you know it?
don't know.
Yeah, the death of the offeror terminates the offer. So that's just a little rule, right? And that's what the question would be about. Right. Yeah, no, because the death of the offeror terminates the offer is the correct answer. And then maybe a wrong answer that comes out right might be something like, no, because an executor does not have the power to blah, 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 or they make it look like a sort of wills and trust question. Or no, because a spouse can only sell community property, or something like that.
So by operation of law, once someone dies,
Any outstanding offers made by them are terminated. Right. Yes. Well, does the death of the offeror terminate? I think it does not. Right. There's still this entity. Right. Yes, that contract is still good. Right, because it's consideration supported. Right. Okay. Next one.
October 1st, I offered to sell you a truckload of Dominican cigars. The following week, Congress passes a law prohibiting the sale of tobacco products. The president signs the bill into law and is effective immediately. You, with your hankering to secure your supply of stogies, call me and accept the offer.
Because?
Because if it's an illegal contract.
Right. Can't form an illegal contract. Even if it was legal at the time the offer was made. Right. The law that governs is the law in effect at the time you seek to accept. Right. Not the law in effect at the time the offer was made. So it's not that it was an invalid offer when made. It was a valid offer when made, right? But it can't be accepted, and even if accepted, it couldn't be performed, right? Now there would be a defense to non-performance, which would be illegality. Right, so again, that would be, a question might be about that, right? Yes, the contract has been formed, but it doesn't have to be performed, right? Which would be the wrong answer, versus a contract hasn't even been formed. To not perform. Correct. Right, but that's the distinction. That's a distinction that one might test there. Okay, next one. Contract or no contract? Yes. What the rule? It is, and we'll get to that, but the little sub-rule that's being tested here is that you can accept and add additional terms and conditions if you're not rejecting the terms of the offer, right? So if they offer a price and you offer a different price, that's a rejection. But if they offer a price and you then offer a delivery date or FOB or whatever it is, that kind of counteroffer is not a rejection. Or it's not a counteroffer to accept with additional terms. So acceptance plus additional terms does not equal a rejection of the original offer. Yes. Yeah, this is a UCC rule.
But then the offeror can reject the additional terms?
Yes.
Right? But then
Yeah.
there's still a contract formed due to the original.
Right. So this may or may not have been the very first thing you learned in your contracts class. That is, your contracts class might have started with offer and acceptance, or it might have started with consideration, because consideration is the thing that differentiates all the many, many promises that we make in life from the enforceable promises that are called contracts. Right? So the gratuitous promise is not a contract. Not every promise is a contract. The difference between ordinary promises and contracts is that promises that are consideration supported on both sides are contracts, and hence enforceable in the event of their breach. So not every promise is a contract is one of those things that you learn early on in your contracts course, hopefully. Sometimes it's the very first thing, right? That is whether gratuitous promises should or shouldn't be enforceable and why, right? But the rule is gratuitous promises are not enforceable. Only promises supported by consideration are enforceable, which is to say, are contracts. What counts as consideration and how much consideration do you need? So the first slogan here, right after the first rule that people learn, which is often, this is like, when people start to think law school is weird and the law is weird, is on the one hand, the gratuitous promise is not enforceable. It's one of those slogans you learn in contract law. And shortly after that, you typically learn the law will not inquire into the adequacy of consideration, right? That is, it's not, the enforceability of a contract does not depend on whether it's a fair price, whether there is an exchange where each side seems to be getting something of the same value, right? Assuming that the contract is made under terms that do not make it subject to various contract offenses, fraud, and so forth, the law will not inquire into the adequacy of consideration. This is a private law area in which people are allowed to make exchanges on any terms that suit them, as long as those exchanges are voluntary in the way that the law requires. That is not the product of fraud, etc. Right? So it's very important to understand what consideration is without getting caught up in the idea that a contract might be unenforceable because there's not enough consideration. If there's consideration, and that's the only issue in the contract, there's a contract, even if it seems to be radically inadequate, but not going all the way to the point of the contract itself being involuntary and hence subject to contract offenses. So what can count as consideration? There's a whole bunch of things that are easy and obvious, right? That is the thing of value, money, right? Or another thing of value can obviously count as consideration. A promise, that is a promise to perform or a promise to pay, is consideration, as is forbearance, right? And anything that's a legal detriment. So forbearing from doing something you otherwise have a right to do is consideration, and forbearing, that is not, for example, pursuing a lawsuit that you have started to pursue, is the consideration that supports every civil settlement agreement. Right? That is, it's always part of the agreement that the plaintiff drop the suit. That's the consideration. The forbearing to continue to pursue the suit against your tort defendant or your contract defendant in exchange for the settlement. What makes that settlement agreement an enforceable contract? Right? Somebody's giving money to somebody else. What's going in the other direction? Right? When you get $10,000 to settle that tort suit, to settle that breach of contract suit, what are they getting? They are getting your forbearance from pursuing the suit, and that's good consideration. If it weren't, settlement agreements would be impossible, right? Because people would take their $10,000, but they could then continue to pursue the suit, and there'd be no way to sue them because there'd be no consideration. So lots of things can count as consideration. You're not going to be examined on things that are especially challenging beyond understanding that the law will not inquire into the adequacy of consideration, and forbearance from doing something that you are otherwise legally allowed to do is consideration. And then kind of the exception to the exception that is sometimes tested is, which also has a slogan, there are many slogans in this area, is past consideration is no consideration. Right? So you can't keep milking the same past consideration. That is, if there's something you were already bound to do, right, it can't continue to serve as consideration for a future promise. And we'll see some examples of that, I think, going forward. It's not how it came into being, that's for sure. Because it predates a world of contract in our style. All right. And again, on the legal detriment side, keep in mind that consideration requires detriment to the promisor, not value to the promisee. So in the example that I just gave, forbearing from pursuing the lawsuit, that obviously is of value to the promisee. It's not just a detriment to the promisor. But in some of these classic cases, the nephew who quit smoking or whatever, you say, how is that of benefit to the uncle? Doesn't matter. Right? It's legal detriment to the promisor, not value to the promisee, that makes something consideration. Well, it's not the offeror, because once there's a contract, there's a contract. right? So generally in a bilateral contract, both sides are both promisor and promisee, but with respect to different things, right? The promisor, with the widget sale, the 100 widgets for $100. The widget seller, right, is the promisor with respect to widget delivery, right? And the promisee with respect to the $100. So you've got to keep track of who's doing what. A bilateral contract precisely means, right, both are promisor and promisee, but with respect to different things, because the contract itself is an exchange of promises. So page 134 just gives us a list. So we want to make sure that we're familiar with these. I'll just take you through it because these are pretty easy. We're coming back to it. We're doing 134 and then 133. So the act or promise to act, yes. The forbearance or promise not to do something, yep. Consideration. The object, land, money, etc., right? That's the thing of value. The settlement of a good faith dispute or lawsuit, and again, I think a better way to understand that is forbearance from pursuing it. Agreement to change a legal obligation or relationship, which is typically to take on some kind of duty, is consideration. Doing something you're already legally obligated to do, not consideration. That's past consideration is no consideration.
That's the first note.
Correct. An agreement with an unrestricted right to cancel, not consideration. And the past act, that's another version of past consideration is no consideration. Okay. All right. And now we will swing around to page 133 and questions 4 and 5. Are you next? Who's next? Are you next? It doesn't matter too much. Okay, go ahead, go for it. So we have 2 questions coming out of a relatively short fact pattern, but I don't, again, even if that is less likely to happen now, we can take a look at what the 2 questions are about and then swing back to the facts. So what's question 4? Okay, so we're going to have a consideration question, right? And what about number 5? All right, so this is a kind of question that we didn't see in our tort review. This is the first time we're encountering this kind of question, and it's a hard question. It's a harder level of question than some of the other types of questions that we have seen, many of which are simply about recognizing the presence or absence of elements of a claim. These questions are a little bit more judgment call-ish, and they're harder because of that. And there are a few variants, right? What would most strengthen the claim? What would most weaken the claim? Right? What would be the best argument? What would be, right, the weakest argument? Those are harder, and they require a little bit of a different kind of analysis, so we'll talk about it a little bit when we get to it. But now we can read our story, which is, after all, not so long. Okay? All right. Okay, so there are potentially a few different things going on in here. Some of them confusing because they don't have much to do with contracts, but they implicate some slightly complicated issues of marital property law. Like, what is this question even about, right? Because there's like wills and trusts and inheritance stuff going on, and what's it doing here, right? So let's figure out what the state of, before we even answer the questions, let's figure out what the legal state of affairs is in paragraph 1, right? And we also want to keep track of the order of events, right? So Brill saves the life of Ace's wife, Mary, okay? Is that or can that be consideration for anything? No, because it wasn't done as part of any kind of contract, right? He just did it, right? And now with respect to anything that happens later, it is going to fall under the heading past consideration is no consideration, right? Saving someone's life is a thing that could be consideration, right? But not here, right? Because it's the first thing that happens, right? Nothing that happens before there's even an offer could possibly be consideration for any contract, period, ever, right? Under whatever theory you want, right? So we already know enough to answer question number 4, which is our yes or no question. Which is the better no answer? C or D? Yes. Neither of them is exactly great, right? Because the rule here is past consideration is no consideration. But if he had asked him to save her, arguably, I mean, I would tell the story differently. She's drowning. They're by lakeside. Husband can't swim, right? Wife is drowning. He turns to the guy standing next to him and says, if you can get my wife out of the water, I'll give you $1,000. Okay? That is an offer of a unilateral contract to be accepted by performance. He jumps in, he drags her out, they have a contract. Right? So it's not that saving someone's life can't be consideration. Of course it can. Almost anything can be, right? But not if there's no contract, right? And so this act is performed before we have any of the other indicia of a contract, right? And so there can't be a contract here, right? And D is kind of in the general area of the law will not inquire into the adequacy of consideration, right? It sort of seems to be suggesting because we can't maybe put a monetary value on it, is $1,000 the right amount? But that's just the wrong way to think about it, right? Wrong way to think about it. Now, what about A and B as bad answers, just so we have them? Okay. Yeah, forget it. Forget it. Nothing to do with the law of contracts. And what about B? Well, it was only after she died, right? So first her life is saved, later she dies. Not relatedly. This is kind of, the trap of B is this idea, is sort of this equitable idea that if someone does something of benefit to you, you might owe them something, or quasi-contract. But that's not this, right? Quasi-contract is when there's been an agreement that ends up unenforceable for some reason. Does someone get a windfall? No, we find a way, right, to cover the person who has done something that benefited the other at legal detriment to themselves. That's not the department that we are in, right? So 4 is the easier question, 5 is the harder question, right? So he saves her life, right? She changes her will, right? But when the time comes, why isn't there any money for him? Because actually he neither took it nor inherited it, but he becomes its owner by operation of law, right? She's a tenant by the entirety with her spouse, and her interest is extinguished. We'll talk when I teach you the law of wills and trusts. We'll talk about how to think about what happens, right, to the share of joint tenants. And the best way to think about it is that the first joint tenant or tenant by the entirety to die, their interest is extinguished, right? It just disappears, right? It's best to think of the surviving spouse or surviving joint tenant as having an interest that expands to fill the entire property. They don't exactly get something. If their interest, correct, it just expands. And there are many metaphors in this area to which I will introduce you, right? And that's what, it's like it grows or expands to cover the entirety of the property with the other interest being extinguished. Nothing is passing from person to person. That's a mistake, right? It's not like that, right? It's not like that. So the point is she doesn't own anything, right? But she's not in breach of anything, right? In fact, her promise to leave him $1,000 is a gratuitous promise. He has no rights based on that. Now, because past consideration is no consideration, right? And so saying, in gratitude for his saving my life, saying to him, I will now leave you $1,000 in my will, right? Even if she had thousands of dollars and left him out of her will, he would have no action against her estate.
But it says Mary, you thereafter changed her will to leave $1,000.
Big deal. Doesn't mean a thing.
So if she dies intestate, the will states that she leaves.
Then she won't be dying intestate.
Oh, intestate means that.
Right. Right. But every gift in a will, I mean, again, we'll talk about this when we talk about the law of wills in detail, right? Every gift in a will is a gratuitous promise. It's just a gratuitous promise. It's a gift, right? Sometimes it is consideration supported, which might give someone a cause of action against the estate if they have been left out. But that doesn't change the fact that every gift in the will is a gratuitous promise that then, right, is effectuated by the death of the person. So she dies, there's nothing, and her husband, we think sort of, he wants to carry out the wish, right? So in consideration of him saving his wife's life and his agreement to bring no claims against my estate based on her will, right? Now, is that good consideration? His forbearance, right? His forbearance he promises to pay, right? Then upon his death, he files a claim for the $1,000, right? Contested the claim. So now we're in question 5. With respect to the recital that Brill had agreed not to file a claim against Ace's estate, what additional fact would most strengthen Brill's claim? So the easy question here would have been, is that good consideration? And the answer to that is yes, right? Forbearance is good consideration. But we've actually been asked a slightly more difficult question. What additional fact would most strengthen his claim? We can't generate an answer easily here because we don't know what our choices are going to be. So let's take a look. So what's A? Does it strengthen the claim? Right. I mean, better to have it in writing than not to. So depending on what the other answers are, that might help. Is this the kind of promise which the statute of frauds requires to be in writing? Because? And it can be performed in less than a year. Right. So it's not as if writing is yes, no about the enforceability. So at least that is, I mean, that's a plus factor. It would help, right? But it really depends what's coming later, whether it will be the thing that would most strengthen the claim. What about B? Okay. Okay, so that's a plus. More of a plus factor than the prior one, but again, we don't know what else is coming. Irrelevant. Right. Yes, that's correct. Because if he didn't believe that, then arguably somebody's got to believe that there's something of value there, right? Right, right. Okay. All right. The next page that we're going to do is totally out of order, but I think it actually is better here than where it originally appears. So it is page 145 or 146 little I, maybe, or oh, I guess I originally called it 146 little I because there were some non-numbered pages. 145, don't cop out is what it says across the top. And this is also a consideration question, and so I think it actually is more helpful to do it at this stage. And so call the question, and then I'll make a few comments about detrimental reliance and promissory estoppel.
In an action against Gray's estate for $2,000 on account of the 2 A's, if the only defense raised is lack of consideration, Esther probably will.
Right, so this is a question about lack of consideration, and that's why we're going to talk about it now. That is what can and can't be consideration, right? This is a lack of consideration question. So now we can talk a little bit about detrimental reliance or promissory estoppel as consideration-related questions. I think it's also, I would also like you to have a little bit more complete definition, right? Our materials say these are not contracts concepts at all, but rather are equitable rules that allow a party to avoid the technicalities of contract formation and to ensure justice. I guess the way that I would put that is that they're equitable rules or equitable concepts that allow a party to obtain justice even when contract formalities have not been complied with. Right? So the idea is the person who's going to be protected, right, is one who has generally performed, but contract formalities have not been complied with. And the idea is we don't allow someone to use the lack of contract formalities to get out of performing themselves when the other side has performed. Because then it's using those contract formalities to kind of take advantage of someone who has performed, notwithstanding that all the contract formalities have not been complied with. And so it will allow either a contract or a quasi-contract to come into being to protect the performing party against a breaching party who is using the lack of formalities as a defense. Right? That's the situation we are concerned with. Right? So you want to be careful in choosing these as an answer. That's kind of the strategic point. Don't jump on them too fast as an answer, right? Just because there's fancy legal language about promissory estoppel and you don't quite remember what it is, and so you think that might be the right answer. But you do want to be aware that there are situations in which someone can get a remedy, notwithstanding the fact that contract formalities have not been complied with, right? But typically the absence of consideration is not going to be that formality, right? So someone's detrimental reliance is potentially consideration that will bring a contract into being, or alternatively, will potentially allow them some recovery in quasi-contract. So you've got to read the question closely, right? But this is one where, I mean, again, we'll see over the course of the next couple of months, we'll have our list of, check common sense at the door and our don't check common sense at the door, as you may recall from yesterday. When someone has performed in a way that both imposes detrimental reliance on them and benefits the other side, and then the other side doesn't want to pay up and points to the lack of contract formalities, right? This is common sense is going to say you don't get something for nothing. Now that's different than someone who paints your house when you never asked them to paint your house. That's a different thing, right? This is someone who paints your house when you've negotiated a deal and you think you've agreed, or they think you've agreed and they reasonably think that, and they show up and paint the house and you don't stop them, thinking to yourself, I'm going to get my house painted for free because we didn't actually have a contract, because it's $1,200 and had to be in writing and it wasn't in writing, or whatever it is, right? Common sense will tell you, no, you don't get something for nothing, right? That's different than unilaterally attempting to force a contract on someone by showing up and painting their house when we never asked them to do it. All right, so you want to sort of be sensitive to that distinction, right? When common sense and fairness would tell you someone is entitled to some compensation versus someone unilaterally trying to force a contract on somebody else, which will not work, right? So now this is potentially a lack of consideration case, and now we'll read through these facts.
When Esther, Ray's 21-year-old daughter, came to college, Ray handed her an assignment stating that if she would go to law school, she would give her tuition and board, and would give her a $1,000 bonus for each day she got in law school.
Oh, and where are we as a matter of a contract?
We're at the offer stage.
Okay.
Esther's uncle Miller, who was present on this occasion, read the memorandum and thereupon he said to Esther, and if he doesn't take it, I will.
Who is he in contract terms? And we don't have a contract yet, but if we do, who will he be?
Well, he is our surety.
Yeah, he's surety or a guarantor, right? We don't know if the question is going to be about that. Since we have looked ahead to see that this is a question about consideration, we can be relieved to know this is not actually going to be a complicated question about the obligations of the surety or guarantor, but another question about that could certainly be generated out of these facts and might be, in another universe, we're not going to have to worry about it, right? We've read the call of the question, and that makes that sentence irrelevant.
They
Right.
paid her tuition when the board for her first year, but died just before the end of that year. Subsequently, yes.
All right, so is there a contract?
Yes.
The offer is accepted by? Yes, that's the look of it, right? It looks like she went. We don't have some separate communication, but off she goes. And one of the things that's sort of a little weird or funny about it is, what is her consideration? What consideration is passing to him?
It's her performance.
Well, right, but her performance is her acceptance, right? But what is the consideration?
Well, her consideration is the same thing as remaining in school and doing well.
Right. I mean, what's strange about this is that a detriment to her? But doesn't it have to be a detriment to her in order to be consideration?
Well, there's a difference between a detriment and a legal detriment.
Okay.
Okay.
So
And in this
if-
case, what's distinguished is that she has a bargain for legal detriment to go to law school. Now, one may say that is.
And
not
why is it a
detriment
legal detriment?
Because she's committing herself to a specific course of action. for a
Right, that
specified period of
she's
time.
not otherwise obligated to do.
do.
That's the thing, right? It's like the quitting smoking when you have a right to smoke, right? So even though we think this is a benefit to her, it's a legal detriment because she doesn't have to do it, right? And so she's subjecting herself, right, to doing it.
Yeah, she can spend the next 3 years serving.
That's right. And by doing, even though maybe she really wants to do this, right? So you're right in saying the distinction is between detriment and legal detriment, but we sort of want to keep an eye on that, the way that she accepts is by her performance. But what makes this consideration supported is that she's doing something she didn't otherwise have to do. Okay? Okay. He dies, right? But there's already a contract. So this is not like the offeror who dies, right? There's already a contract in place. Right? Go on.
Subsequently, Esther learned that she had received 2 A's in the second semester. The executor raised the state and he has refused to pay her anything for the 2 A's and has told her that the estate will no longer pay the tuition for law school.
All right, so now she is seeking to enforce. Okay? Can she enforce?
Yes.
Okay? And so this, in saying, if the only defense raised is lack of consideration, this is a yes because, no because, right? And the question is really, is there a contract, or is she entitled to a remedy, or is this a breach, right? Those are all questions that would have the same answer. Is there a contract? Is she entitled to a remedy, or was there a breach? Right? Are all questions that are the same yes or no question being asked here. So as between our two yes answers, which is the better answer? Why do you think? What makes A? Do you think A is better than B, and if so, why?
Well, because the doctrine of promissory estoppel is one which, as you stated earlier, exists to sort of vitiate bad faith in the contract process by one of the parties who seeks to sort of welch on a deal.
But it's only relevant if there isn't actually a contract.
It's only relevant if there's not a contract. Okay, so then.
Right, B is the superior answer because A is only a remedy when there's not a contract. Right? A is a promissory estoppel is a remedy available to someone who has undergone a legal detriment in the absence of an enforceable contract. Right? And so that's why I say this is the same as the question. Is there a contract? Has there been a breach? That is, or is the executor's non-performance a breach? Yes, because there's a contract. Because there's a bargain for exchange, including a legal detriment to her. Okay? So let's look at C and D just so we are familiar with them and what's wrong with them.
Not exceed because the $1,000 Well, I mean, D is obviously wrong because best efforts has nothing to do with this type of contract. And that's sort of superfluous type of language. I mean, not succeed because that was pay with promissory bonus. That really avoids the issue here.
Right. These are kind of alluding to a different kind of contract dispute or problem, right? Imagine people have made the contract to perform whatever it is for $1,000 and time is running short, right? And the person who's supposed to perform says, I can only deliver this to you on the day we agreed if you agree to pay me another $1,000. They agree. They bring it in on time and refuse to pay the second $1,000. That's the situation in which they can say, you were already obligated, right? I promised to pay you a second $1,000 and I'm not gonna, because the only thing that supported that was your promise to do what you were already legally obligated to do, and it's not gonna work, right? I agreed to it to get you to perform your original promise, and I'm not paying you more. That's not this situation, right? It's not that kind of best efforts. You're always obligated to use your best efforts, right, in the ordinary contract situation. And so you can't demand more from your promisor to do what you already promised to do, right? But that's not this, right? She hadn't already promised to do it, and then they said, right, and then it's added on, okay? All right, so that's, again, sort of out of order here, but I think this is where it belongs because it really is about what counts as consideration, as well as carrying through with when is a contract formed and what consideration will support a contract.
So again, to review, the doctrine of promissory estoppel is imposed when two parties have
Almost have a
Yeah, they don't
contract
really
is
have
kind of the way to
contract.
put it.
And you have
Right.
performance, and then the person says, hey, wait a minute, we don't have a contract. And then-
I'm not going to
and
perform,
then the
which
person who
usually means
performs,
I'm not going to pay.
They have to go to court and say, hey, wait a minute, I did all this stuff, and then
Right.
the court will say, okay, we're going to
Right. And promissory estoppel is appropriate when the facts are such that the court of finder of fact concludes no one would have done this but for their belief that the other person had promised to pay. And so when you do that, when you knowingly induce someone's reliance on their belief that you're going to pay, you are then stopped from saying, I never promised it. And that's where sometimes letting someone do something and not stopping them they will later be stopped from saying, oh, but I never promised to pay, right? That's that kind of situation. Okay? All right, so back to page 136 and the statute of frauds. So this just is a bulleted list of circumstances where the statute of frauds applies. The contracts involving an interest in land, there's real property. The service contract that cannot, by its own terms, be performed within 1 year. Contract for the sale of goods valued at $500 or more. Promise by an executor or administrator to pay the debts of an estate out of his own funds. That's like a guarantor agreement. A promise to pay the debt of another if that person defaults. That's another question about a writing. Though if the main purpose, right, there's an exception, if the main purpose is the pecuniary interest of the promisor, the statute of frauds doesn't apply. And the promise and consideration of marriage. And what does the statute of frauds require? That is, if the statute of frauds applies, what must be the case about the contract? Well, this is a piece of the determination of the validity of the valid contract where the statute of frauds applies. But if the statute of frauds applies, what must be true of the contract that wouldn't otherwise necessarily have to be true? And even more general, even more inclusive? Yes, in writing and signed by who? Right, so the mantra here is signed by the party to be charged. So if this is an exchange of promises, both parties have to sign because both are promisors. Right? But the idea is the person against whom you later seek to enforce the contract has to have signed it, which is like in a way obvious, right? But I can't bind you by signing the contract myself, right? It'll be in writing and signed, but it won't be signed by the party to be charged, right? So the party to be charged is the party against whom enforcement is sought.
What if the party who begins the action didn't sign the contract, but the contract was signed by the party who was sued?
That's good enough.
That's good enough.
Yeah. Yeah. Yes.
The comments right back here are the, main purpose,
If the main purpose is the pecuniary interest of the promisor, then the statute of frauds doesn't apply. That's the one where it
the
applies.
debt, the surety.
Yes, yes, the second to last bullet.
Okay, yes.
Okay. So we mean, what are the circumstances?
Yeah, this one
Well, the circumstances, I mean, the circumstances that come immediately to my mind, although the statute of frauds would end up applying for other reasons because it would be an interest in land, would have to do with a multiple mortgage situation. And the reason that you're promising to pay the mortgage of the senior mortgage holder is so that you yourself don't get foreclosed on, that if they get foreclosed on, you don't lose your interest because you're a junior lien holder. Now the statute of frauds would apply, but not because of that reason. It would apply because it's an interest in real estate. Yes.
if her uncle Miller,
Okay.
if he had signed something, yeah, I'll pay for, what your dad said.
Right. Right.
That it
The statute of frauds would apply, right? So that on the facts that we have here, the statute of frauds would apply, right? Because this is a surety agreement, right? So that would be, if we imagine writing another question out of this, right? And the question were, which of the following facts would be most helpful to Miller in seeking to avoid performing? It not being in writing would be a fact very helpful to him because he's a surety. Now, I'd have to think about what are the facts that would take us into the exception that the main purpose is the pecuniary interest of the promisor. I mean, it's hard to generate off the top of my head why he would make such a promise for his own pecuniary reasons, because this is a weird kind of, because it's not a commercial arrangement, right? I think it would be much likelier that that would happen in a commercial arrangement where what's happening is you're guaranteeing, an upstream purchaser of parts or goods you need, right? And so if they don't pay, you promise to pay because any delay in getting those goods to you, right, is so potentially damaging to you that you're willing to take on the risk and then sue them later, right? That would be one where I think that would count as the main purpose. Is you're not just doing this as a favor, you're doing this as part of a more complicated commercial transaction. It does. If nothing else puts you in. You could hold me to it. Correct. Correct. If the statute of frauds doesn't otherwise apply. But I mean, these are we're like out in the furthest reaches of statute of frauds type questions. Okay. All right, so now we're on page 135 and 6. Actually, 135 and 138 are the pages I want you to put next to each other because I want to talk about the parole evidence rule together with the statute of frauds because they are related. Right? The parole evidence rule, right, is what? Who wants to state the parole evidence rule? Anyone that you, I mean, again, there are various ways of stating it that are okay. What is it?
That no outside verbal evidence of an oral contract will be admitted upon a subsequent examination of a written contract when interpreting the terms and language of that contract. So evidence of oral negotiation will not be admitted, and the Williston test excludes all parole evidence that two reasonable parties would have committed to writing.
Right, so whether a particular disputed term should have been in the contract can sometimes come into play, right, in a parole evidence situation. The simplest statement of it is that parole evidence is not admissible to vary the terms of an integrated contract. Right? So if the contract is an integration, right, that's the easiest situation. The contract is an integration, which means the contract itself states that it is the entire agreement between the parties. In such a situation, outside evidence will not be admitted to vary the terms. Right? You can't say, it says we agreed to $100 for 100 widgets. But as soon as we signed that, we had this separate conversation where I agreed to pay him, he agreed to pay me $200, and so he needs to pay me $200. That would be a classic example of what won't work. When we think about this in policy from policy perspective, it is easy to understand why we need a parole evidence rule, right? People often, this may or may not have ever happened to you in your life, but it might because it happens a lot. People who want to enter into an agreement on different terms than the terms they are willing to commit to writing. Right? So they commit one set of terms to writing and then they separately agree to something else. Now, if in real life everybody goes along with the non-contractual terms, well, nobody ever finds out about it. I mean, a point that I sometimes make, I often make this in the wills and trust course and in the property course and also here, there are no contracts police running around seeing whether people who've agreed to pay $100 for 100 widgets are actually paying $200 for 100 widgets. No one cares. This is a private law area, right? It only comes before the courts and anybody's attention when something goes wrong, right? So the parole evidence rule affects, we can think of it very much from an evidence point of view, right? And then we can also think of it from a contracts point of view in answering the question, how do we figure out what the terms of this contract are? And the answer is, we look at the contract, right? We don't just look at the contract and then evidence of everything else that anybody might have said at any point about what they've agreed to do, and then try to figure out which is the most credible or plausible or whatever. This is for ease and efficiency of courts, and it's also intended to channel contracting parties into putting all of the essential terms in writing, right? By saying any side agreements, right, the court will not come before the court. So don't think you can protect yourself by making some side agreement to terms that are not the terms reflected in the contract itself, right? So the statute of frauds requires a writing signed by the party to be charged, and the parole evidence rule tells us what will be enforced are the terms of that writing and nothing else, right? So they kind of work hand in hand in that way, okay? So I want us to look at questions 6 and 7 on pages 135 and 138 from this point of view, okay? So question 6 is not set up exactly as it should be, right? There should be a new paragraph that begins with the sentence, if Prue offers evidence, it's 4 or 5 lines up from the above answer A. So that's our question stem. So whoever's next, want to read that question stem? Is that you? Okay. Okay.
If Prue offers evidence in addition to the writing memorandum that the parties discussed and agreed upon a purchase price of $35,000 just prior to signing Prue's deal.
Okay, so if we want to reshape that question even a little bit more, right? Again, we know because we have our heading, right? This is about the statute of frauds and the parole evidence rule, right? So what we have here is Prue offers evidence that there's an oral agreement of a price. We don't know if there's a price above or there's not a price, but that's the department we are in. So we can think about different ways the question might be framed. But the answer is again going to be yes because, no because, no because. It might be about the admissibility of this evidence, which makes it sort of a little bit more of an evidence question, right? But it's implicating the parole evidence rule, which is itself a contracts doctrine. Right, so now we're going to have to go up into the facts, but that's what we're going to be curious about, okay? So now start at the top.
Better and Prue each signed a memorandum that stated that Better agreed to sell and Prue agreed to purchase a tract of land, and that the contract should be closed and conveyance made and accepted by tender of general warranty fee conveying a good and marketable title on the deed specified.
All right, so a question that starts like this, the reason you It would be helpful to read the question stem first, although as you can see, even rearranged, it would be short, and so you might not, is there are a lot of things a question like that might be about, right? Remember when you're taking the MBE, they don't come divided by topics already. And if you started there, you would think, this is a real property question. This is a general warranty deed question. This is a recording act question. This is going to be a who bears the risk of loss question. That's what this sounds like. It's not what it's going to turn out to be, but it's what it sounds like. And so that's a benefit of reading the question stem that's going to tell you it's going to be something else. And so you don't have to like go into a panic because you don't remember what what are the, the covenants of the general warranty deed, which we'll be talking about, but not now. Okay, go on.
The memorandum signed by the parties contains all of the elements essential and necessary to satisfy the statute of frauds applicable to the transaction, except that there was omission of the suspicion of the purchase price agreed upon.
What is the effect of that in a real estate contract? What's the effect? Yes, that's the rule being tested. So it's actually, in a way, a real property question, right? Because in some circumstances, a price can be implied in, not for real estate, right? And often, I mean, what would be a good example of a situation where the price could be implied? Rather than my telling you, I will let you give an example. Course of dealing, right? That is, if you've been buying 100 widgets and from one contract, you've got a contract like this every month for years, and then it somehow is inadvertently omitted, something like that. Course of dealing, I think, is where it would be most likely it could be implied. But every real estate is unique, blah, 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 there's a whole thing. So there's no contract between them. Go on.
That it has refused to perform the contract and an action by proof of specific performance that it relies upon the statute of frauds as a defense.
Okay, so our vendor, right, has refused to perform. Can he legitimately refuse to perform? Right. There's been no performance. He's prepared to excuse the performance on the other side. He's not saying give me the money, but I'm not giving you Blackacre. He's saying we don't have a deal. Okay, go on. And again, the action is for specific performance because real estate contracts are one of the few kinds of contracts where specific performance is available as a remedy, but not if there's no contract. Okay, go on.
So if true offers evidence in
Right, now we've got our question, right? Is this going to work? No, we did. We agreed on a price, right? Right, so we're going to go to fail, right, or no because. Which is the better answer? Yep.
So C says fail because the price agreed upon is an essential term of the contract and must be in writing.
Okay, which is true. So the question is the other answer better, more complete somehow?
So D says fail because the evidence does not show that the price agreed upon is in fact the reason market value of the land.
Right.
So I would go C.
Right, what's wrong with D?
It's irrelevant whether it's reasonable.
The law will not inquire into the adequacy of consideration. Right, so it's not, right, it's irrelevant, right? If it were present, it wouldn't be a defense that it's not the fair market value, and so the fact that it's absent, fair market value is irrelevant, okay? Let's look at A and B just so we know why those are not correct.
A is succeed because Veta is established to deny that such agreed price is a fair and equal one, which will be implied by law as a term of the written memorandum. But price is not implied.
Correct.
B, succeed because the law implies that the parties contracted for a reasonable market price of the land, although the price to be paid may not necessarily be agreed upon. So not necessarily line for
Right, so these are just wrong statements of the rule, especially as it applies to real property. So I would almost call this a crossover question, even though they don't exactly categorize them that way. I mean, when you're dividing them up, I think this is arguably every bit as much a real property question as it is a contracts or statute of frauds question. It requires you to know some rules that apply specifically to transactions in real property, and to me that makes it a real property question, sort of in a way. Yeah. And so too, number 7. So again, read the question stem first, even though again it's a short one where you might not necessarily do that as a strategic matter. So this is page 138. Okay, so again, today the question might be framed slightly differently, but this is the thing that would be most helpful, most hurtful, that harder kind of question, right? That's not just about the missing element or something like that, right? And those are the kinds of questions where you really do have to read all the answers, because even if one is good, another one might be better, right? Finding one that satisfies it doesn't necessarily tell you found the best answer. Since the question tells you that what we're arguing about is the price of homestead, we're again in a little bit of that real property contracts crossover, because the subject matter of the contract is real property, and that means real property specific rules may apply here. And again, in the contracts area, since real property transactions are the easiest, most obvious example of the transactions to which the statute of frauds applies, they're an easy way to examine it, which will sometimes implicate other special rules relating to real property, and sometimes won't, right? Sometimes it'll just be about the presence or absence of a writing signed by the party to be charged. So now start at the top. All right, so there are actually two possible questions here, an easy one and a hard one. The easy one, which we're about to look at, and the harder one, which is about Quincy and Quincy's rights, right? But our question isn't even about that, right? Knowing what our call of the question is, you basically, you don't want to cross it out completely because you might use it to generate a question of your own. Everything about Quincy can be omitted, right? It's irrelevant to answering this question, right? We have an oral agreement to sell at what price, right? And a written agreement to sell at what price? Okay. So, which is the best answer, do you think? Because now what we want is buyer refuses to pay 45. Seller wants to say, no, it was supposed to be 46. Which of these is going to be the best argument for him to get the 46,000? Yes. Just mistake. Just mistake. It's not parole evidence to vary a term, right? It's parole evidence just of mistake, right? We agreed at this price, right? It's not, we said we agreed at this price, but we actually agreed at a different price. It's saying we always only agreed at 46,000, and the fact that it says 45,000 is just a pure mistake. Now, sometimes such mistakes can be corrected and sometimes they can't. It's not that there would be a guarantee that the mistake could be corrected, right? But it's the best argument. So let's look at the others and evaluate them. That's not going to help matters. That means it's fake, it's phony, it's a fraud, it's pretend, right? So that would be, someone might try to make such an argument if they say we agreed at 45,000. And then we created this writing that says 4,000 because that was going to make the taxes on the transaction much less. But we always meant 45,000. That is a non-starter, right? That is not going to work. Okay? Right, and the term they're trying to vary is not one that was omitted. Right? So that would be an argument if there was nothing about the dates or something like that, or some other term of the escrow, and they say, no, this was part of our agreement, but the writing was only a partial integration. But the term at issue here is in it. So that's not going to help. Well, it isn't true, but it also wouldn't help. Because if it were true, what would be the consequence? no contract. No contract, no meeting of the minds. Right? So that won't help him get more money, right? That will help him not perform because it would help him, it would prove that there was never a contract.
But the existence of the signed writing 45 is actually in contrast to that statement. The evidence of the mistaken signed contract shows that there really wasn't any misunderstanding.
Well, it might, I mean, the suggestion here, without again like digging in too deep, would be to say the reason that I signed it is because I thought that was the price we had agreed to. The reason he signed it was because he didn't read it carefully. There was never a meeting of the minds. That would be the suggestion. Okay. All right, so now we're going to turn our attention to some of the commonly tested UCC rules, starting on page 139 in question 8. And as the creators of our materials accurately say, a favorite fact pattern of the examiners involves destruction of the subject matter of a contract, and if we're going to be more precise, it will be destruction in transit, so that it's unclear who bears the risk of loss. The way to put it would be that risk of loss is a commonly examined subject. So you need to understand when risk of loss transfers as compared to when the goods transfer, or when possession of the goods or custody of the goods transfers, because risk of loss does not always travel with the goods, as it were, right? Sometimes risk of loss moves ahead of the goods and sometimes behind the goods, etc. So the example will be a deal, or the question will be a deal relating to the sale of goods. Sometime before the buyer gets her hands on the goods, something horrible will happen to them, that is in transit. And the buyer sues, right? But sometimes the buyer sues, but it's not always the buyer who sues. So I think that is maybe an oversimplification. What happens is the goods are destroyed in transit, and the buyer either sues for a different set of goods, or the seller sues when the buyer refuses to pay. Right? The buyer says, I didn't contract for a case full of crushed dinner plates. Send me a new set of dinner plates. Or I didn't contract for a box of crushed dinner plates. I won't be paying for them. And the seller says, oh, yes, you will. Right? So it may be the seller who's suing because the buyer refuses to perform. Or it may be that the buyer has performed and paid, and what arrives is a box of crushed dishes, and they say, how about you send me another box of crushed dishes because this does not count as performing. Right? So it all depends on the order of events. It's not always the buyer who sues. Right? Sometimes it's the seller who sues, arguing that the risk of loss transferred when I put the box on the truck. It's not my fault they got crushed. You still owe me the $1,000 or whatever. Okay? So whether the buyer can recover or the seller, right? That is, whether anyone can recover depends on whether the risk of loss has shifted, and if so, when. Okay? Or seller, S. For breach of contract, it might be that it will fail because there's no contract. There might be offer and acceptance issues in here. It might be that it'll fail because there's no contract and there are consideration issues in here, right? We're now moving our attention to performance and risk of loss, but it's not obvious if the question is just in an action for breach of contract. It could be about anything, right? So you've got to read the facts and see what it's about. Okay? So start at the top.
In a written contract, owner agrees to deliver the buyer 500 dispatch shares at $20 each at location in which place is. The contract requires that neither party will sign the contract without written consent of the other.
All right, so here there's a little bit of strategy and so on in question reading. Mostly, I'd have to think about whether there are exceptions, but I think there mostly won't be. If they call it a contract, it's a contract. Right? That is, they're not going to call it a contract and then there's no consideration or improper acceptance. They might call it an agreement, a writing, a letter, a communication in their right. But I think if they actually call it a contract, it's a contract. Right? So this is not going to be a question about was there consideration, right? Was the offer accepted? It's a contract, right? And you don't need to worry about that. Don't second guess them from that point of view. And we will revisit this in some other settings, including wills and so on. Okay? All right, so it's a contract and not assignable. Maybe that's relevant, maybe it's not. Okay, go on.
Singer placed the chairs on board of the carrier on January 3rd. On February 1st, Singer said in the signed writing, I hereby assign the wheel
All right, so what's the significance of that, if any? I mean, remember, we've jumped ahead, right? And so we know the question we're being asked. Again, we could generate another question out of it, but the question we're being asked is about buyer versus Singer. Has nothing to do with Wheeler, but what subject matter is being alluded to there? Well, there's an assignment of a non-assignable contract, so it's rules about assignability. Is there like some kind of novation going on in there? Is Wheeler going to have any rights? Is this going to be effective? Is it a material breach to have assigned or attempted to assign at all? That might be floating around out there, but we don't know yet what our question is about. Okay, go on.
February 2nd, the chairs long transit will destroy railroad.
Right. So really our concern is not this stuff about Wheeler, right? The chairs were put on board the carrier on January 30th. They were destroyed on February 2nd. Buyer is suing seller for breach. That is, we can assume buyer has already paid and is saying, send me another bunch of chairs. Seller is refusing, saying, when I put the chairs on the carrier, they were fine. My responsibility is at an end. Who's right? Has the risk of loss shifted, or has the risk of loss not shifted? Correct. So now now we have to choose between buyer probably will not succeed, that is the no, right? Which again might be set up like this, or might now say, in an action by buyer against Singer for breach of contract, will buyer succeed? Yes because, no because, no because. Which is better between C and D? Right, this is a risk of loss question. Why is that superior to C? Right, and even if it's not about those chairs, right? That is, if what seller has done doesn't count as an adequate performance, he could still perform, right? You could put another bunch of chairs on a train, right? So it's not like that these chairs are no good is not the point, right? This is not like it's the Mona Lisa you put on that truck, and if it's destroyed, it's destroyed. It's not like that, okay? So what about A and B? How are they not? I mean, B is just the alternative to D, right? That is who bears the risk of loss. If you just don't know the rule and you're guessing, you're going to be guessing between B and D, and there's not much we can do for you. What about A? Right, doesn't work like that, right? Not for these purposes. Okay. All right, so on page 140, we have a worksheet that will take us through some of this risk of loss, and then on 141, we've got a little more about impossibility, so that helps us to distinguish those kinds of answers. So let's go through these. These are about who bears the risk of loss. As you notice, each of these, the question is who bears the risk of loss. Okay? All right, so first one. Right, computer store. Put another way, no shift. Right, the crucial moment that we're looking for in each of these situations is when does the shift occur? Here, the shift has not yet occurred. When does it occur? Right, when the buyer takes possession, the risk of loss shifts to him. Right, if he which again follows our intuitions. If he goes to the computer store, picks up the computer, walks outside, drops it, and breaks it. It's not on the computer store, it's on him. Right, so when the buyer takes physical possession is when the risk of loss shifts. Okay, next one.
Abigail owns one computer.
Again, this is not a merchant. Now it's not a merchant. Our prior one, a merchant. Now not a merchant. Go on.
She contracts to sell it to Sarah. If the exchange will take place on Wednesday, Sarah decides to wait until the weekend to pick up the computer from Abigail. On Friday, the computer is destroyed by a fire. Who bears the risk of loss?
Right, has it shifted is another way to put it. And if so, when?
I would say, I don't know the answer.
Okay.
Yeah,
Right, you would be mistaken. For the non-merchant seller, when does the risk of loss shift? No. Right, and if you want to put it in a more general way, how would we describe? Right, it's when the goods become available.
Oh, okay.
Right, for the non-merchant seller, the risk of loss shifts to the buyer when the goods become available. That's the rule for the non-merchant seller. So for the merchant seller, the risk of loss shifts when the buyer takes possession. For the non-merchant seller, the risk of loss shifts when the goods become available. That's the difference between our first and our second examples. Third example?
Bicycle wholesaler in contract to sell 50 bicycles for cycle leasing company. The bicycles are placed on a truck that is destroyed in a highway accident and sold to the owner, including unrepaired.
Right. Did the risk of loss shift, and if so, when? Right. So, FOB. When it's FOB, the seller. Or I'm sorry. When it's free on board to the buyer, the loss shifts once the goods are loaded. I'm sorry, I'm wrong. Since it says, my note was right and then I thought it was wrong, but my note is correct. Our third example is free on board seller's place of business. Right? FOB, bicycle wholesaler's place of business. Bicycle wholesaler is the seller. When it's free on board the seller's place of business, the loss shifts once the goods are loaded. The next one is going to be the other example. Right, so look at the difference between the third and the fourth example. Bicycle wholesaler contracts to sell 50 bicycles to Cycle Retail Inc., FOB Cycle Retail Inc. Now it's free on board the buyer. Here, when it's destroyed, the risk of loss has not yet shifted. So free on board the buyer means there's no shift of risk of loss until the goods are received. That is, are in the physical possession of the buyer. And now, the last one we can do aloud. Right? I think this is one where who bears the risk of loss is not quite the right way to think about it, right? The question is, and I think a likelier way that it would be presented is, does widget manufacturer have to send another 1,000 widgets or not? But what about the sentence before that? Right, right. So that really the question is, do they have to ship? Because from seller's point of view, the question is always, am I going to have to replace the destroyed goods? These are not just any destroyed goods. These are goods that would have been rejected even if they hadn't been destroyed. Right? So it's not about risk of loss, right? It's about their obligation to comply, because the goods they sent weren't in compliance with the contract anyway. So it's not about who bears the risk of loss. It's, do they have to send another 1,000 widgets? And the answer is yes, they do. Right? They don't get to have a windfall because their defective widgets were destroyed on the loading dock, and hence there was no chance to reject them. No, if it's FOB seller, the loss shifts once loaded. If it's FOB buyer, there's no shift until the buyer takes possession.
So that means that would be, if it's FOB the buyer, once the goods are off of the train, so if they arrive at the buyer, but they're still on the train and there's some update, it's still, the risk of loss is still.
Yeah, until they're in the custody of the buyer.
So they would have to be off the train
Yeah.
before
Yeah, in the custody of an agent of the buyer or the buyer.
So like in this last one, if the widgets were not defended, then it was the buyer's place of business on resellers loading not to be considered.
Yeah, because it's there. Now it's in their custody. Right. Okay. Impossibility, we just have a bulleted list that you want to be familiar with. We're not going to belabor it. It's not, I think, super complicated. This is page 141. That is, it has to be really impossible following the time the contract was entered into. And again, whenever we see this, like the offer acceptance situation, it must be completely impossible or only discharged to the extent it's impossible, and permanently impossible just temporarily, though that will interact with something about which I will have a little bit to say, not a huge amount, which has to do with when time is and isn't of the essence. Right? Because if time is of the essence and performance is impossible, that's different than if time is not of the essence and performance is temporarily impossible. And service contracts, impossibility must be unique services that cannot be delegated. All right, on page 143, we're going to jump ahead and then do question 9, the question about Wheeler, right, that we avoided before in talking about the assignment and the contract that's not supposed to be assigned. Okay? But first, I want us to do the little worksheet or little chart that's on page 143. So, can a contract obligation be assigned when there's a clause that says the contract may not be assigned? Yes, right? Unless there's like a separate contract for that, right? That is just saying the contract can't be assigned is like just saying the offer can't be revoked.
So you need separate consideration for that.
Correct. Okay. But can a contract obligation be assigned when the assignee knows that there is a non-assignment clause? Answer, no. So that's the exception. So yes, the contract can be assigned even in the presence of a non-assignment clause, but not if the assignee knows about the non-assignment clause.
This is the third party.
Right. Has to be. Has to be. They're not the person on the other side of the contract. Right. So it's their rights that we're really protecting. Right. This is like the BFP for value. Right. They're the next person who comes into the picture. Right. And the assignment, right, will be protected unless they knew. Right. Unless they knew that they were receiving the assignment in violation of a clause in the contract. Can a contract obligation be assigned when the contract says that an assignment is void? No. So there's a difference. This is like one of these hyper-technical differences between something that just says this contract is not assignable and a provision that says any purported assignment of this contract is void. Can a contract obligation be assigned when the contract says it is void upon assignment? Also, no. There's a typo replacement word that we need for the next one. It reads, can a contract obligation be assigned when the assignment would subsequently change the risk to the non-assigning party? But that's not the word. This is like a autocorrect or its predecessor. It should be substantially, not subsequently. So can a contract obligation be assigned when the assignment would substantially change the risk to the non-assigning party? No. And can you sue the assignor for the assignee's breach? Yes, you can, unless there's a release, which again is another agreement, consideration supported, etc. In other words, an assignor cannot get out from under their obligations by assigning. They can assign even in violation of a clause that says they can't assign, but they can't thereby get out from under their obligations unless there is a release, which is effectively a novation, right? A new contract with somebody else. Okay? So now we have our Wheeler a question that a question coming from the same fact pattern that we saw, which is now about the assignment to Wheeler in violation of the non-assignment clause. so now, what happens? All right, so what's our next question? Who's our next question reader? Okay.
Reenacted by Wheeler against Fire, Wheeler cover. In a written contract, signer agrees to deliver by a 500% guarantee $20 until the signer closes business. Contract provided that neither party will sign the contract without a written the other. Signer, singer, placed chairs on board a carrier on January 30th. On February 1st, singer said in a signed writing, I hereby assign to Wheeler all my rights under the singer fire contract. Singer did not request and did not get fire's consent to this transaction. February 2nd, the sheriff loan manager for this derailment and carriers bill.
Right, so a question about the action by Wheeler against Bayer alone, right, which again now typically there's only one question coming out of a fact pattern, right? This is a much harder question if this were the only question, because it requires you to solve both of the problems here. One is to figure out when the risk of loss shifts, and then the other is to figure out the effect of the assignment, right? Because if the risk of loss hasn't shifted to the buyer, there's nothing to sue the buyer for, right? So first you have to figure out whether the risk of loss has shifted. But even if you do that right, if you don't understand the effect of the assignment, you won't get it right, right? So we've already figured out, right, that has the risk of loss shifted or not, right? So the risk of loss has shifted. That means the contract is enforceable. So the question is the contract enforceable by Singer's assignee, Wheeler? That is the assignment effective? Why or why not? Correct, it prohibits the assignment. But does it say any assignment is void? No, it doesn't.
Fire still has to pay singer. Wheeler has to.
If the assignment is effective, all of Singer's rights are now Wheeler's rights, including the right to sue buyer. So is the assignment effective or not? That's the first question, and you have to know what that means. This assignment is effective. Yes. Yes, it doesn't qualify for any of the exceptions. The contract doesn't say an assignment is void, and there are no facts to suggest that it changes the risk in some way to buyer, right? Because it's not that kind of thing, right? It doesn't matter to buyer who he pays his money to, right? That doesn't affect his risks, right? So yes, this is an enforceable contract. That we already figured out because the risk of loss has shifted. And yes, this is an effective assignment, which means that all the rights that Singer used to have, Wheeler now has. And so, what is our answer? Right, the contract price. Wheeler is just enforcing the contract. He's stepping into Singer's shoes and enforcing the contract. Now these answers might be arranged a little bit differently. What is answer B? Well, and that's the profit on the contract. But that's not all that's been assigned to Wheeler, right? It's all my rights, right? Not just the profit on the contract, but the whole contract. C would be where you would go if you come out on the wrong side of the risk of loss analysis. And D is where you go if you come out on the wrong side of the assignment analysis. So there are a lot of ways to get this question wrong and only one way to get it right. And that makes it hard. Right? That makes it hard. It's not like it's a much easier question when the wrong answers are just wrong statements of law, as opposed to wrong results of a multi-step analysis that can go wrong in a lot of places. That's a hard question, right? Not because each of those rules is so hard, but because putting it all together is hard. Right? It's a fine distinction between an assignable contract and a non-assignable one, and then it's also important to understand, then you have to know this risk of loss stuff, which is also not simple. So it's hard. I would consider that a hard question.
I'm confused, but this kind of goes to an assignment. If there's an assignment clause in the contract, and
A non-assignment clause?
a non-assignment
Okay.
Sorry, there's a non-assignment clause in the contract. And then, so say here, Singer says in writing he assigns it. So say before the chairs are destroyed, the other party objects to the assignment.
Well, whether they can object to the assignment will depend on whether any of the exceptions to it apply. Right?
So even if they object to it in this situation, nothing applies to it, so the assignment will still be valid.
Right. Now that's different than, I mean, we'd have to add facts to it.
Yeah.
If, like, they were going to be different chairs now, right? And it's like, no, I want Singer-made chairs, not Wheeler-made chairs. I'm not paying that price for Wheeler-made chairs, right? Then that would be right, because now what, in effect, the assignment would be like changing the contract, and that you can't do. But if all that's being assigned is who you write your check to, what's the basis of your objection? I don't want to write a check to them. That's not anything. Okay? All right. Question 10, page 144. Okay? It's short, right? So you can read the question, but it's so short, we can also just take it from the top. Okay?
Adult, who has been keeping in contact with this for 10 years, with prime reputation. Contract between two barns. The Green Barn is a standardized barn in the law. Contract has no provision regarding the assignment. Adult assigns the contract to Sue, who has terrible experience or reputation, which is the following statement.
Okay, so again, today, questions would not be which of the following is most correct, right? Today the question would probably read, if Adel assigns the contract to Coot, is it valid, right? Or may Adel validly assign the contract to Coot, who has comparable experience and reputation? That's probably the way we write, right? So may A assign to C, who has comparable experience and reputation? Yes. Another way the question might be phrased is, if A assigns to C, who has comparable experience and reputation, must B accept the performance? Would be another way to put it, right? Also yes. So which answer? Right. So let's take a look at the other answers just so we can eliminate them. Right. Contracts are presumptively assignable. Right, there are things you can do to make them not assignable, but they're presumptively assignable. This one's silent, so that's just wrong. Right. Right, this is B and C, or yes and no, about whether you can refuse to accept performance from an assignee of comparable experience, nothing special, no details. Right, yes. Right? Okay. Right. A novation is a new contract. This is not a new contract.
Now, let's say you're talking about somebody who is like a famous singer, like contract to.
Right, then it's unique. Then it's a unique performance. Right. So sometimes comparable experience and reputation is enough, and sometimes it isn't. Right, you can't just swap in any.
Carreras can't come in.
Correct. Right, if it's truly unique. But this, we're being told it's all standard and right, same reputation. Right, so that's being made easy for you. It's actually cueing you, if you know enough to know it makes a difference, that those things don't matter here. Okay. All right, so the next area that we want to talk about is third-party beneficiaries. And again, pages have been numbered in various ways, but I think what you want to be looking at is 144 little a and little b next to each other, which is just understanding who a third-party beneficiary is and what third-party beneficiary rules there are. Right? Our basic rule is that only intended third-party beneficiaries have contractual rights. It is often the case that A and B enter into a contract for the benefit of C. There are some familiar examples of this. One that I've often used because I think it makes it easy to remember, but maybe more so for parents than for other people, is, for example, the private school contract between parents and school for the education of child. Right? That's a situation where there's a third-party beneficiary. Otherwise, sometimes you want to have some ready example in your own head of why A and B would enter into a contract for the benefit of C instead of C just entering into the agreement on their own. And there are various reasons why that might happen. But the idea is third-party beneficiaries who have rights, right, who are intended to be beneficiaries of the agreement, will also have rights to enforce it in the event of the breach, because the breach will be damaging to them. So, how do we know whether someone is a third-party beneficiary? We have three choices. The party is identified in the contract, or the party receives the performance directly from the promisor, or has a relationship with the promisee that indicates an intent to benefit the third-party beneficiary. So the example that I gave satisfies all of them, right? The private school contract will include the name of the student, right? The third-party beneficiary will receive performance directly from the promisor, the school, who promises to provide them an education for such and such an academic year, and has a relationship with the promisee that indicates the intent to benefit. Why would parent enter into a contract with private school? Right? Parent is an adult. They don't need that elementary school education, but their child does. And so the relationship between A and C, that's why A is doing this on behalf of C, because A is C's parent. But again, that's a donee beneficiary. That is, C is not giving any consideration. Another situation of third-party beneficiaries are creditors to whom the promisee owes a debt. So the promisor will be paying the creditor. Right? So the promisor on the promise to pay side will be paying the creditor. Right? So here's the idea. I owe somebody $5,000. I don't have it. You and I enter into an agreement by which I will paint your house for $5,000 to be paid to my creditor. Instead of paying me, you pay my creditor for my labor. Right? I give you my labor, and instead of paying me, you pay my creditor. My creditor is a third-party beneficiary of the agreement between us, right? And thus will satisfy. They should be identified in the contract. That is, all the proceeds are to be paid to so-and-so, right? It's not that they're going to receive, they will receive performance from the promisor in terms of the payment, right? The payment will go directly to them, and their relationship with me is my creditor. So that's another easy example. Those two models, I think, are useful for a donee example, right? Parents, private school, and child. And for a creditor example, debtor, recipient of services, to be paid, with payment to be made directly to creditor. Third party's rights have to vest in order for that party to have the right to enforce. And before that happens, A and B can modify or rescind. That is, they can change their minds. The rights vest either when the third-party beneficiary makes a promise in a way specified by the terms of the contract, brings a suit to enforce the promise, so it may be that the vesting happens exactly as they sue for breach, or materially changes their position in reasonable reliance, which is going to be much more typical, obviously, of the creditor beneficiary, easier to prove. So imagine, for example, in my $5,000 house painting example, that the statute of limitations on the debt is about to run. I enter into this house painting agreement, and as a result, my creditor doesn't sue me, and the statute of limitations runs. Well, now, right, I can't say, remember that house painting agreement? Forget about it. Because now the creditor has materially changed their position in reliance on the fact that I was going to paint the house and they were going to get the payment. Okay. The third-party beneficiary can sue the promisor or the promisee, as the case may be. But donee, that's creditor, third-party beneficiaries can sue anybody. But donee third-party beneficiaries can only sue where there's been detrimental reliance. So the creditor example that I just gave, yes, but the donee beneficiary, like even the child's private school agreement, probably not. And ordinary remedies still apply, right? So the parents can still sue the school if the school fails to perform, even though the child could also sue the school. They don't lose their rights. All right, so now let's take a look at questions 11 and 12.
Which of the following is true with best serve the owner as a defense of an action brought against him by Jones for $5,000?
All right, it might be that in the question as it would be phrased today, it would be clearer that it's a contracts question, right? And it's going to be a question about defenses, and that could be lots of things. Remember, statute of frauds is a possible defense. Lack of consideration is a possible defense, right? We don't, that there was no contract, right, is a possible defense. We don't know. So take from the top.
On Mark 1, mechanic agreed to repair owner's machine for $5,000 to be paid on completion of the work. On March 15, before the work was completed, mechanic sent letter to owner with a copy to Jones, telling owner to pay $5,000 to Jones, who was one of the mechanic's creditors. Mechanic then
So you get the idea of what's happened, right? They're transferring the right to receive the payment to their creditor. Okay?
mechanic then completed the work. Which of the following is true with best serve owner defense action brought against him by Jones for $5,000?
So the creditor is suing the promisor owner who's refusing to pay the $5,000. Without reading them, we're not going to be able to assess good defenses, bad defenses, which is better, which is worse. So we'll just take it from the top. Start at A.
A. Jones was incapable of performing mechanic's work.
Has Jones promised to perform mechanics work? No, this is not even relevant, right? That might be relevant if what mechanic transferred to Jones was the responsibility for fixing the machine. And then he says, what are you doing transfer? He's not a mechanic. I'm not paying him. But that's not what he transferred. What he transferred was the right to receive the money. So A is irrelevant. What about B?
Mechanic did not perform his work in a workmanlike manner.
Why?
Because the manner in which he did the work is not relevant to this problem.
To owner's obligation to pay?
Well, it's not. The only thing that's relevant is if the work was completed successfully or effectively.
I think that's the same thing.
Really?
Yeah, as a word, yes. I think that's meant to be the same thing here,
Okay.
right? So is this a ground for refusing to pay anybody?
Yes.
Right. So the question is it going to be the best answer for a reason not to pay Jones, the creditor? We don't know. But it is at least a defense to paying anybody at all, right? That you didn't fix it, right? I'm not paying I'm not paying you, and I'm not paying your creditor either. I'm not paying anyone because you didn't fix it. So that's possible, though there might be a better answer. Go on.
On March 1, mechanic had promised owner that he would not assign contract. Well, no to this because all contracts are presumptively assignable.
Right. Unless it says it's right.
Notwithstanding promises otherwise.
Correct.
And then D, Jones was not the intended beneficiary of the owner of the contract, but that's just a mistake.
Right, and it doesn't matter for this kind of performance, right? Because all he's at, right. And so there we are with B, an answer that isn't even about the assignment, really. It's really a straight up contract defense. You haven't performed. That's why I'm not going to pay. I'm not going to pay you. I'm not going to pay anybody because you haven't performed.
It's kind of confusing language, though, to me, because, again, it doesn't state that the work was ineffective or poorly done. It just says.
I think it's
the manner
meant to.
in
I
which-
think it's meant to say that, though. It may not sound like that to you, but I think it is meant to say that.
Well, I mean, you can do something in a manner that is very leisurely and takes a lot of time, but
Right.
the job can get done.
Yeah.
But you can do something in a real workmanlike manner that gets done very quickly.
It's correct. No, it's not.
2 minutes.
Yes, it's not fantastically worded. So in some cases, it may be a little bit of a process of elimination. But I think part of the point that's being made here implicitly is that any defenses to paying are always defenses to paying. It doesn't matter who you're paying. If you have a defense to paying, you have a defense to paying that will transfer to the creditor.
Yeah, and in this case, the other three are so bad that it's the only one that's not.
Even possible, right. All right, next one. So here, let's jump ahead to the question, which would be pulled out into its own paragraph.
If Nisi learns of owner's payment to Artesian on May 5th at the same time she learned of the written Artesian owner's contract, will she succeed in action against owner for $5,000?
All right, so we have no idea who's doing what to who. We don't know who these people are, so let's take it from the top.
On January 15th, in a signed writing, Artesian agreed to remodel owner's building according to certain specifications. Owner to pay the agreed price of $5,000 to Artesian's niece, Roberta Nisi, as a birthday present.
All right, so this is a donee third-party beneficiary situation, not a creditor situation, a donee third-party beneficiary, right? Artisan wants to make a gift to niece, and a gift of money to niece, has skills, is going to use these skills to owner, and says to owner, give the money to my niece as a gift. That's exactly like the house painting setup that we described before, except that was a creditor, this is a gift. But you get the basic structure. Okay, then what?
Niece did not learn of the agreement until her birthday on May 5th.
Okay.
Before they signed the writing, Artesian and the owner had orally agreed that their written agreement is null and void unless owner is able to obtain a $5,000 loan from the First National Bank before January 31st.
Okay, so you get the idea, right? That they've entered into this separate oral agreement, right? That says if owner can't get a loan, there isn't any $5,000, and so the other thing's going to be void. Okay?
Assuming that owner obtained the loan,
Right, thank goodness, because the much harder question is if they don't. This ends up being just a little detour for us. Okay, go on.
that Artesian completed the remodeling on May 1st, and that on May 3rd, at Artesian's request, owner paid the $5,000 to Artesian.
Okay, so you see what happens, right? Gets the loan, right? And then does the work, but instead of paying it to niece, the artist has basically changed their mind. They need the money themselves and says, remember when we said before, right, to give it to my niece? Don't give it to my niece, just give it to me. It's given to that person, and then a couple of days later, the would-be third-party donee beneficiary finds out, right? And now we have our question. If the niece learns of the payment to Artisan on the 5th at the same time that she learns about the original contract that was supposed to have a gift for $5,000 to her in it, will she be able to get the $5,000? What do you think? Right. Right, and I think even this is not a check your common sense at the door. This is a use your common sense, right? So this is a yes because, no because, no because. Let's look at our no because choices.
C, no, because niece have not furnished any consideration to support owner's promise to pay $5,000 for it.
Okay, good answer, bad answer.
No, because if it's a donee, then
Right, but I think this is not a terrible answer, right? Because it's really an answer that is defining her as a donee beneficiary. And if she had given consideration, she'd be in a different position. So this is a possibly right answer, right? What's our next answer?
D, no, because on May 3rd, Artesian and owner effectively modified their written contract, thereby depriving niece of whatever rights she may have had under that contract.
Okay.
So I would say that is the better answer.
I think it is a better answer, but again, C is not a terrible answer, right? There are other things that could be answered. C is a correct answer, actually. It's
For this
just
problem, C is
no.
correct.
D is the right answer, but C is also true, right? So depending on what D is, C might have been the right answer. C is not a bad answer, even though it's the wrong answer. What about A and B?
A, yes, because she is an intended beneficiary of their written.
And that's, of course, true. It just doesn't give her the rights she wants to have. It's the wrong answer for the right reason, right? And what about B?
B, yes, because their written Artesian owner contract operated as an assignment to Nisi, and Artesian thereby lost whatever rights he may have had to the $5,000.
And that's, again, no, because he's a donee.
So the reason, so the donee beneficiary doesn't have any
Yeah, donee beneficiary doesn't have much. The donee third-party beneficiary doesn't have much by
So their
way of
don't
rights.
really ever vest because the donor
They
can
don't-
change their mind.
Right, now, but a donee can change their position in reasonable reliance.
But that was-
Right, that's not in these facts, right? And then it's sort of a detrimental reliance kind of situation, right? Or they could have been, I mean, this person is originally mentioned. It's just that then the contract is changed. So it's not that this person isn't in the contract. They are in the original contract, but not in such a way as to prevent artisan and owner from changing the terms of their agreement, which is what they do. That is, once they render their agreement potentially canceled entirely, right, her rights have not vested.
But so for a donee to learn of their rights doesn't necessarily mean their rights are vested.
Correct.
Unless they
Unless they change their position in reliance, right.
So for instance, she on January 15th got a copy of the writing signed by both of them, and she went out and bought a car for $500.
On credit, knowing this money's
Credit,
coming in,
knowing
and
the
they
money's
knew it,
coming in,
and they knew it.
They knew that she did it.
Right.
Then she would.
Her rights would have vested, that's right. Okay. And now breach, and then remedies, and then we'll be done. The basic idea, right, is that one party's material breach excuses the other's performance. We're now on page 146, little b, is the way it was numbered. On the other hand, a minor breach does not excuse performance. The heading on the page that I'm looking at is once more into the breach. 146 little b.
Ours doesn't have a page number.
Not even handwritten on it? Okay.
it's the second to last page.
Yeah, but then we're going to swing back around because we've got remedies to come back to. So yes, I'll try to be sensitive to that.
We're still on this
We are on once more into the breach. Right? So whether a breach is material or minor makes a big difference. But one of the things that means is that if it shows up on the bar exam, it is likely not to be a gray area. It's going to be quite trivial or the essence of the agreement, right? Because it affects whether the other party is still obligated to perform. And you're not going to be asked in a multi-state bar exam question to make a very fine determination of whether someone's breach has excused the other's performance. It will either be really trivial or kind of total non-performance. You know, they don't deliver the goods, you obviously don't have to pay for them. You order, 900,000 pieces and they deliver 899,999. You might get a little price break, but you don't get total relief, right? For the, because it's one paper clip short, right? So again, you're not going to be asked to make some close determination there. An essay question might call upon you to discuss, right, with a breach, how material is it, how much performance does this excuse, or is there a price abatement, or what? An MBE question is not going to do that. Okay? So there are lots of factors to consider. The amount of benefit received by the non-breaching party, whether damages can adequately compensate, the extent of the partial performance, the degree of hardship to the breaching party if they're held to the agreement, also the behavior of the breaching party. Are they a bad guy or a good guy? And how likely it is that the breaching party can cure it. In general, the non-breaching party has a duty to mitigate damages. And if that duty is breached, that is the duty to mitigate, damages will be reduced by the amount that could have been saved had the party mitigated. So you can't just sit on your loss. Right? You have your million paperclip contract, and they're going to totally not deliver. You got to go get yourself 1 million paperclips. And if you have to pay a little more, that will be covered in damages. But you can't just not even go looking for paperclips and then get all the damages resulting from not having them. Unless the contract says otherwise, time is not of the essence. So that's important and easy to test. All right, a party who fails to perform within the time specified is probably not, as your materials say, not in material breach unless the contract specifically states that time is of the essence or the nature of the contract makes timeliness essential. I guess kind of the way that I would put that, or the thing I would add to that, is that the party who fails to perform within the time specified is probably not in material breach yet. Not yet. right? That is, you can't sue them the very next day, right, unless the contract said time was of the essence. If it becomes clear they're never going to perform, that's a different story. Liquidated damages clauses are enforceable generally if two requirements are met. Damages are difficult to ascertain at the time of contract formation, and the amount specified is reasonable. In real estate contracts, 10% of the purchase price is pretty much regarded as reasonable, but in most other areas, there's no bright line rule. If the amount is not reasonable or greatly exceeds what could have reasonably been anticipated at the time of the contract, it will be viewed as a penalty clause and not enforced. So you can't say, you sell me 100 widgets for $100, and if you fail to deliver, it's $1 million. That's not going to work. Okay. All right. We're now on what were pages, I mean, I've renumbered because I've reordered, but your questions 16 and 17. That's the only heading that's on the page if your pages are not numbered. For me, they're numbered 146 little c and 146 little d, but it's your questions 16 and 17. Okay. And this is also a question of a style that we do not see much of now. It's not exactly the two questions coming out of one stem. It's in a way even worse, right? It's a question and then facts are added to the question and another question is asked, right? This may in some ways show up in an essay. It's less likely to show up in this kind of a structure, but we want to make sure that we understand the law regardless. So question 16. All right, so today we would be given more about this, right? We know it's a breach, right? So it would be likelier now to say, if all sues Hauser for breach of contract, will all prevail? Yes because, no because, no because. Or under prevailing American law or under the majority approach, will all prevail in a suit against Hauser for breach of contract? That's the question. So with that in mind, let's read the facts. Right, so we know our question is a suit by A against H, right? Wait, I just want to say more. What is the breach that will happen? How can H breach? What is H's promise? No. Those are the description of the work A is going to do. That would be how A could breach. Right. So the possible breach is H's non-payment. And what that means is that A is going to perform and H is going to refuse to pay. And the question is going to be, is A's performance going to be enough to bind H to paying? Or is A going to have done some breach that relieves H of the duty to perform? That's the question. So you want to be sure you're keeping track of who's doing what to whom. Okay? All right, so now go on. All right, that is exactly the example that I gave you before, right? If you recall, right? Of someone who agrees to perform at a certain price, then says, I can't perform at that price, you have to pay me more. And when the other person agrees to pay them more, right, does the other person actually have to pay them more? No, past consideration is no consideration, or it's not consideration to do that which you already have a legal obligation to do, right? Does A already have a legal obligation to build this house for $60,000? Yes. Right? So he's not in a great position here, right? What he's doing is really halfway a new offer, halfway an anticipatory breach, right? Okay? So So now go on. All right, so we're now in a weird situation. You see what's happened? Right? We've got a contract for $60,000. Then A says, I can't do it for 60, you have to pay me 90. And H doesn't respond and instead finds someone else to do it for 75. This is a much clearer case than the motorcycle case. You're not building two houses on the same lot. You could buy two motorcycles. You can't build two houses on the same lot. But we're not in an offer and acceptance situation. We already have a contract, right? We have contract number 1 to do the work, and we now have contract number 2 to do the very same work, right? There are many complicated questions that could be asked about this. Let's see which ones they're going to ask us. So now go on. All right, so now A is going to sue H. Is A going to win? Because? Well, that's part of our problem, so it might show up in the answer. Well, it's weird to say that because you can't unilaterally terminate a contract, right? He's bound. Right, really, it's an anticipatory breach to say, I'll lose money at that price. I can't do it unless you pay me $90,000. That's basically saying, I'm not going to do what I agreed to do, which is an anticipatory breach of contract. If someone then covers, right, you can't, I mean, if we think about this as goods, right, I can't give you the paper clips for $60,000, you've got to pay me 90, and someone goes and gets the paper clips for $75,000. You think you can force your paper clips onto them? Not now. He was out there covering. He was mitigating his damages. You can't now force him back into the agreement you anticipatorily breached, right? So he's not going to win. Let's see which is our better answer. So the way it's set up here is who wins, right? So H, that is H won't be held liable, right? Which is the better answer? Okay, why? I mean, this is A's total breach, right? That is an anticipatory breach. What about B as an answer? Give her a chance. That's right, isn't relevant. I mean, if he'd gone out and made a contract with someone else for $100,000 because he believed that A couldn't do it for less than 90, but just decided he didn't want to do business with A, right? A still would be in breach, right? He's still free to enter into an agreement with someone else. Would he be able to get that $10,000 difference from A? That is, if his new contract were for $100,000? Probably not, all right? But not the point, okay? And what's wrong with C and D? Right. Right. Right, that's the crucial thing. It doesn't do any good, right? His anticipatory breach gives Hauser the right to go out and cover. Now it is 1, but we started a little bit late, and I would rather finish. Can we finish? Okay. So I mean, it's not going to. We're closer to the end than it might seem. We've just got a few pages to go. Okay. So now let's build on some additional facts because we understand our question. You can continue with the same question. But now we're going to have a lawsuit going the other way with added facts in number 17. Yeah. Remember, they had agreed to 75. Well, right, this is the question, right? So this is the one that's going to make you do the math. How much can H get from A, right? Right, and you see there are lots of possible ways to try and figure it out, right? So you want to be keeping an eye on the ball, right? Because the difference is cover price minus contract price. Correct, correct. Right, that he actually couldn't bring it in for 75. A is not responsible for that part, right? What A is responsible for is the difference between the cover price and the contract price, right? Not the actual price. So I suggest you read those through, make sure you understand them, but given the shortness of time, right? It's the contract price of replacing the breacher. That's what the breacher is responsible for.
So 25.
No, 15 is what he has. Right, he doesn't have to pay that additional $10,000.
Oh, he does.
He doesn't, because H doesn't have to pay it. That's G. This is the same thing. This is G saying, I agreed to do it for 75, but guess what? I want 85. H decides to be a good guy, but that part's not A's fault. A's fault is the difference between 75 and 60, not the difference between 85 and 75, or the difference between 85 and 60. Right? Specific performance. I'm just going to make a few quick comments. The standard remedy for breach of contract is damages. Okay? 137. Right, because we have to do breach before we do damages. Right, it's a little out of order. So I'm sorry, I'm reordering. So this is now the page 137 called Frolic and Detour, Specific Performance, and the rules about it. The basic idea you want to keep in mind is that the standard remedy for breach of contract is damages. And specific performance is always an exception. You have to know what the exceptions are, but it's always an exception. It's one of the biggest things that turn the layperson into the law student or lawyer when you realize that the standard remedy for breach of contract is not specific performance. What courts do is not make people do the stuff they've promised to do. It makes them pay for the damages that result from their failure to do it. Right? So everybody who thinks what you get when you enforce a contract is making people do the stuff they promised to do, that's only true when what they promised to do is pay. It's not what happens in the other circumstance. However, there are some important exceptions. Refusal to transfer land. Specific performance is available for real estate. Always on the seller side, and sometimes on the buyer side if the jurisdiction is one that has mutuality of remedy as an important principle. But it's a fine distinction between the purchase price and damages, right? When you're enforcing the contract, they're very similar, right? The key is if I show up and tender the payment for Blackacre, I get Blackacre. I don't get the damages resulting from my not being able to get Blackacre, I get Blackacre, unless, of course, it's been transferred to a third party. Bona fide purchaser for value takes without notice. We'll talk about that when we talk about real estate. Land or other unique goods. Right? Those unique goods get land treatment. The personal computer, no, not unique goods. Right, that's the unique goods. Singer refuses to perform. Can you make them perform? No, you can't. Can't make people do stuff. Buyer refuses to receive goods he contracted to purchase. You can't make him take them. You can make him pay the price, right, if you can't resell the goods. But you can't force goods on someone. You can't say, you will take these widgets. You can say, you can pay me what it cost me to be stuck with these widgets, but you can't force goods on somebody. No. That's the non-unique goods. That's the widget case. And now we have our last two questions, which are your questions 12 and 15. So your question 12, Page 146.
What did Johnson tell me because the rules were not?
Okay, so the word non-conforming tells you that what we're going to be talking about is that might be here. Right, for the difference between the value of conforming goods and non-conforming goods, that's possible. What else might you be able to do if someone gives you non-conforming goods?
What I can do?
Mm-hmm.
Oh, I can, depending on if there's visibility, I just take that piece that's installment of it.
Right, pay less,
Take that.
right? So that's what we want to be thinking of. Now let's look at our answers. Are there any we can eliminate? Right, what would that be? Make these goods conform? Right? So we can eliminate that one. What about the next one? Right, it's because it's possible, right? Okay. Because? Of the law, right? That is, the contract may provide that the buyer pays before the goods are delivered. That doesn't give you the right not to reject non-conforming goods or to have a remedy for that. All right, so now read through the facts.
Johnson bought 100 bowls of standard food, number one quality from the field. Sales contract provided that Johnson would maintain prior to inspection, and the bowls were shipped to Johnson Davis Food. On inspection, however, Johnson discovered that the wool was number two quality. Thereupon, he suspended back the wool in the field and demanded return of payment. He refused on the ground that there is no difference between number one wool and number two wool.
Okay. So which is our better answer now? Because of the facts. Right, because he paid. So obviously he doesn't just get the difference in the value, he gets his money back because he paid. Then he's got to take his money out into the market, buy conforming goods, and if that's going to cost him more, he's entitled to that too. So this is one where we just don't know between B and C what happened in the facts, so we have to read them. But the others can be eliminated, so you can be very focused on just choosing between those, and then that's a pretty easy question. Okay. And now your question 15.
So C's really just covered.
Well, because he's paid in advance. It's fact specific. So it's a more complete and appropriate answer, right? If he'd never paid anything, then B would be the appropriate answer. Okay. All right, and our last question of the day, 15. Okay, and again, it would probably be phrased somewhat differently because what best state, this is which of the following is most correct. But the question is going to be who's obligated to who's breaching who, right, against who. All right, so now take it from the top.
Seller contracted in writing to deliver Baker 100 bushels of August 1st, 2021. Because these suppliers are not delivered enough weeks to verify that time, seller on August 1st had only 95 bushels to deliver. Given the contract to Baker, the seller.
Okay, so now we have our question, right? So this is about whether this is a performance or a non-performance that excuses the obligation. Okay, so let's see what our choices are and we'll evaluate them.
Sure. Seller was deposit back on Baker because seller was changing on the contract.
Okay, what do you think?
The remaining
Well, only if he is effectively forcing the 95 bushels onto the buyer. No, he's prepared to tender them. Baker doesn't want to take them, right? Baker says, you owe me 100, I don't want to take 95. And the question is whether Baker can say, I won't take 95. So the question is 95 substantial performance of a contract for 100? Right. We're going to need to read other answers, right? Because I think it's not totally obvious. So let's go on. Is it impossible? Yeah, he could go. This is not the Mona Lisa, right? So it would be a pain. It might be expensive. It might cut his profit margin down to nothing. That's not impossibility. Okay? All right, so B is out.
Baker has a cause of action against seller for seller failure to
Right. That's like A and C, right? Did he perform or did he not perform? That's the judgment call you have to make. And what about D?
Baker is obligated to give seller a reasonable time to effectuate claim through other private
Right, there's a date and an amount specified. I mean, I think it's that to say he's obligated goes too far. He could choose to do it, right? So if the question is, could he choose to accept performance on August 3rd? He certainly could, right? But he's not obligated to. So as between A and C, what do you think? And I think C is the right answer. But I think if you encounter a question like this, it will be even clearer. Because I think this is a closer call.
Yeah, I was gonna say, guys,
You'd be told more about why he needs all 100 or something like that.
95%
Yeah, I think often 95%.
substantial part performance.
Yes, I think it often would be. I think it often would be. And so I think you want to make sure you're clear on the rule. I think you would be less likely to encounter the facts in this form. And so that would be an understandable one to miss here, even if you understand the rule well. All right, that's it.